Milord, sir, Milord, I am a higher secondary school teacher working without salary, Milord, for last 20 years, Milord. I am working without salary. On last time, your Lordship permitted me to file an application.
July last week.
Milord, I filed the application for salary, Milord.
802. 802. Yes.
May please, my lords, the date is showing on 27th. My lords, I'm paying for not to be deleted.
My lords, the
804. It is not in the list. 804. 804, please. Let it be in August. July or August.
Lords, this is the matter which was a reserved judgment. We had filed an affidavit that is not come on the record because of the judgment reserve. So, my lords, may just we've handed over the copies other day on the matter. And even the written submission.
Lily.
Oblige, my lord. Even the written submissions have been filed.
Online thing.
Oblige, my lords.
Lord, I'm requesting for a passover. I'm led by Mr. Siddharth Dave. He's on his legs. Grateful, man.
Yes, please, my lord. Yes.
My lord, we have served the complainant, my lord. Since it was a complaint case, your lordships had asked the state to serve the complainant, my lord. The service is complete, my lord.
Where is that service report? Office report doesn't indicate so.
No, my lord. Affidavit of service has been filed, my lord. The office report indicates that affidavit of service has been filed. My lord, one opportunity may be given, my lord. The complaint.
I'm behind the wall from more than 2.5 years. This I'm saying, my lord. And this is FIR has been registered after a delay of 3 months. And there is an allegation on the basis of information received from one Jagat, my lord. I can show.
Come, it's all right, otherwise I'll pass the order.
My lord, the complainant has been served. He has to be heard. Otherwise,
What we can do if they are not
no, that's
coming?
correct.
You see the situation in this
My
case.
lord, that's correct, my lord.
Have you seen the
Summons were issued, my lord. He did not appear, and thereafter NBW was issued, my lord.
Why we have keep it inside? 21 directly comes in the pay. And in the
My lord, I'll leave it to your lordship.
entire case is based on it. 201 is there.
That's correct.
Substantial evidence
That's
case
correct.
is there. 2 year, more than 2 years is in custody. That what he was found lying on somebody has said, oh, all these persons have did it.
That's correct. My lord, I'll leave it to your lordship.
We are keeping in Passover. Let us see. If somebody comes, then it's all right. Otherwise, we'll pass.
Please.
Lords requesting for a short Passover. Item 5. Who filed this letter, sir?
Lordship, State of Kerala.
Huh?
State of Kerala filed this.
Why, sir?
The entire case is created just to avoid the payment, my lord.
Just please. Why this letter, sir? For behalf of the state in a bail petition?
Lordship, we are seeking some time to file counter, Lordship.
Who denied you to file the counter, sir? We have not denied you to file the counter.
Lordship, I'm only requesting a week time, Lordship.
All right, a week's time. Yes, sir, during vacation.
Okay.
A week's time is free.
Can we keep it for Friday,
File the counter is allowed. List during vacation. Being regular bail matter. List during vacation. Yes.
Your lordship,
Milord, I appear for the petitioner through VC. Milord,
Yes.
may I please highlight, Milord, few important facts. The offences charged are under section 420 and 409 IPC. I have been in custody, Milord, for more than 4 years and 7 months. Milord, may kindly see the impugned order at page number 4, please, Milord.
filed a counter last night.
Please tell us what is your contention?
Your Lordship, he has 5 criminal antecedents which he has not disclosed in the synopsis, which is
May
again.
not have, madam, please 4 year, 406.
Your Lordship,
9 case,
he has,
keep it
so,
for a long time.
Your Lordship, the trial is not going ahead only because he's in Jaipur court for another, he's there. He's not in our, if the Lordship may have the custody certificate. In the Delhi prison, he's only been there for 3 years.
Where is the custody certificate?
It's part of the SLP, Your Lordship, page 135.
Yes, custody certificate.
This is to certify that as per jail records, inmate, namely Ravi, son of so-and-so, resident so-and-so, was admitted in jail on 11/10/21 in case FIR number so-and-so under section 406, 409, 420, 120B IPC, PS EOW Delhi, and afterwards, he was sent to outside court production at Jaipur Court, whereby the Honorable Court of SDM Jaipur ordered to keep the above inmate in Central Jail, Jaipur, Rajasthan, in case FIR number so-and-so on dated 25/12/24. Since then, the above inmate is not readmitted in this jail as on date. The total period of incarceration in Delhi prison in respect of the above inmate in FIR number so-and-so under section 406, 409, 420, 120B IPC is from 11/10/21 to 20 and 15 days, Your Lordship.
Milord, may I please only highlight, Milord, one thing at page number 112, please, Milord. Milord, page number 112 is the part of the charge sheet.
Your Lordship, part
Milord,
of the
may
charge
kindly
sheet
see.
also includes that he was the authorized signatory
Milord,
of the
Milord, please.
complaint against which 156 complaints have
Ma'am,
been
please
made.
permit
The
me, that's my
magnitude-
petition. Milord, page number 112, Milord, is the list of the cases. During investigation, following below mentioned cases have been found to be registered against Gajanan Kaushik, Ravi, Rajesh Kumar Laura. Milord, 5 common cases against all the accused persons. My co-accused Rajesh Laura has been granted bail. Milord, who was the main conspirator, who was Milord posing himself as the CMD.
Your Lordship, Rajesh Kumar Laura did not have section 409
Milord,
against
that's
him.
true, Milord. Milord,
Clear
but my
case of
right to
409.
speedy justice
It's an
has been,
admitted fact.
Milord, my right to
Your Lordship,
speedy
may have
justice has been
page
violated in this
55.
case.
Please, one by one.
Your
Ma'am,
Lordship
please
may have
permit
page
me to
55
complete.
of the charge sheet.
Milord, that,
Please.
Milord, kindly permit me. Milord, my right to speedy justice has been violated, Milord. Milord, there are 152 witnesses. Only 3 witnesses till date has been examined in chief. Milord, I'm sorry.
132 or 152?
Milord, 152.
152, Your Lordship.
Yes.
Milord, 152 witnesses, only 3 have been examined in cross. No cross examination has been done. Only chief has been done, Milord, for 3 witnesses. Milord, like this, Milord, I will be kept under custody, Milord.
Done by you, sir.
Milord, I'm sorry.
Cross examination is to be done by you, not by any other.
Milord, I have not been produced in the court.
Your
For more than, Milord, nearly 10 dates, Milord, nobody.
Not been produced in the court. Any document to that effect?
Milord, there are order sheets, Milord. I can bring them on record, Milord. Milord, as the state has submitted, Milord, I am lying in Jaipur jail.
Whatever it is, sir, whatever the argument you are advancing, at least that must be on record on the
Milord,
basis of some.
Milord, today I am only on the sole argument, Milord. My right to speedy justice has been violated, Milord. Milord, this honorable court in the matter, Milord, SLP criminal 7416 of 2026, Milord, has held, Milord, Vaibhav Singh versus State of Uttar Pradesh. Howsoever the grave offences, Milord, when Article 21 is impeached, when right to speedy justice is violated, Milord, bail should be granted. Milord, this is order dated 29/4/2026 by Milord Justice J.B. Pardiwala.
Okay.
Your Lordship, if I may.
Anything else?
Milord, on the delay part, Milord, last thing, Milord, on the delay part. Milord, may kindly see page number 4 of the impugned order, please.
पापा आपको नहीं लग रहा कि वो क्या बोलते हैं दोनों पंखों का वो खराब हो गया कंप्रेसर उसका तो बिल्कुल ही नहीं चल रहा जो भी यहाँ ये पैसे रख लो पापा
Your Lordship, if I may. The delay in trial is because of multiple reasons. Your Lordship may have the counter affidavit. We put that on record.
Milord, High Court has dealt with the delay at page number 4. Milord, para number 10 of the impugned order. Milord, para 10 I am reading at page number 4. As regard the delay in the trial, the same is explained by learned prosecutor on the ground that order of framing charges was challenged by Rajesh Kumar Laura by way of revision petition and the matter remained pending there. The prosecution evidence commenced on 24/6/2025 and by now 3 witnesses have been examined as per IU. Further delay was also caused because supplementary charge sheet against 2 persons who have responded were also declared proclaimed offender was filed on 21/8/2023. Now, my lord, here the charge was framed, my lord, in 2023. My lord,
Your
it's
Lordship,
page number 119, annexure P4. 4/8/2023 is the date of framing of charges.
Your Lordship, after that, there is a history. One of the accused had challenged the order.
Madam, why you are
No,
speaking?
no,
He's doing now.
my lord,
Not
this is
understand.
I
Is it a
apologize.
mannerism, sir?
I apologize, Your Lordship.
Please sit.
my lord, first charge was framed somewhere in 2021. My lord, one of the accused, Rajesh Kumar Laura, challenged. Matter was remanded back for reconsideration. My lord, annexure P4, page 119 is the order on charge. My lord, this is the second order on charge dated 4/8/2023. My lord, may kindly note here, page 119, bottom, the paragraph, my lord. Argument on point of charge is heard qua Rajesh Kumar Laura. My lord, this petitioner was not granted the opportunity to argue also. My lord, may kindly note this. My lord, the last paragraph, please, page number 112. My lord, I am reading from 121 bottom. Therefore, I am of the considered view that there was a criminal conspiracy between all accused persons and there is sufficient material to frame against accused Ravi, Gajanan, Rajesh Kumar Laura, Star Global Star so and so, and my lord, charges were framed. 420, 409, 120B. My lord, may kindly peruse the entire order, my lord. My lord, the arguments were not advanced by this petitioner, my lord. My lord, what a prejudice.
Yes. That is all?
That's it, my lord.
Yes, please. What do you want to?
Your Lordship, with respect to his argument that he was not given a charge, Your Lordship, he has not challenged the order framing charge.
Madam, if one accused challenges an order of framing of the charge and that proceedings remain pending, then the High Court observed that the order of framing of the charge was challenged in the challenge. Therefore, there is no delay on the part of the prosecution. Can it be a ground to dispel the delay?
I'm obliged, Your Lordship.
So
Apart
this
from
delay
that,
by this region as assigned by the High Court is not justified.
Your Lordship, there are
I think you
multiple.
will agree of it.
I am obliged, Your
What
Lordship.
do you want to say?
But
now?
there are multiple reasons, Your Lordship. There were other accused who were absconding. There were supplementary charge sheet.
Suppose other accused are absconding. What is the fault of this man? If other accused are absconding, so it is your fault. Your prosecution agency is unable to get them.
Your Lordship, kindly peruse the magnitude of the case. There are 156 complaints all over India against
Maybe,
these.
madam, what
Your
is it
Lordship may
mean?
have the charge
So
sheet for a
meaning
minute.
thereby after 4 years will not grant the bail. After 3 years will not grant the bail.
Your Lordship,
in a 406 cases.
I
We are failing in our duty, madam.
Your Lordship, I'm obliged. However, 409 is a life imprisonment punishment. He has 409 against
Does it
him.
mean, madam?
There are clear evidences against him, Your Lordship. There is a signed lease deed which he has filed of the office
I'm not doing
premises.
in the High Court in the manner it is the passing an order. We should have passed an order against him even structures against such judges. Not considering the things in the right perspective. They have to understand what they are doing. And every day Supreme Court 15 bails per week, 450 bails with every bench. Supreme Court has become now a court of bail.
I'm obliged, Your Lordship.
Thank you. Gaining on for the parties. We find parties as per custody certificate we find that in the present case petitioner was brought in custody 11/10/21 same to court in FIR number 412 of 2022 registered by PS Jatbada, Jaipur. Registered. Thereafter, he has not been brought to the custody in this case. Registered. Primarily, it appears by the said custody certificate that his custody is of 3 years and 2 months in this case. Registered. So far as the other cases are concerned, we cannot embark upon the facts of that case. But looking to the facts of the present case in which the charges were framed on 4/8/23, and by this time, only 3 out of 152 witnesses have been examined. Please stop. Petitioner counsel contends that he has not been produced from the custody to the court. On the other hand, counsel for the respondent submits that the delay is on account of the accused persons because they are not cross-examining the witness and the other co-accused persons are absconding. First of all, after hearing learned counsel for the parties, we find that in a case where the charge against the petitioner has been framed on 4/8/23, and only 3 witnesses have been examined on which the cross-examination has not been done. Full stop. The endeavor ought to be taken by the prosecution to conclude the trial at the earliest, and if within a period of 2 years and 10 months, only 3 witnesses could have been examined, such delay cannot be attributed to the accused. Full stop. In our view, the findings recorded by the High Court is not justified, and without going through the material facts. Full stop. In this view of the matter, at present, we are without expressing any argument.
Your Lordship, if I may, Your Lordship may record the appearance of learned ASG SD Sanjay in this matter for the respondent. Your Lordship may record the appearance of learned ASG SD Sanjay in this matter. I'm appearing on oblige. Your Lordship.
Just not further.
May it please your lordships.
Yes.
This coming up after notice, my lord. In this case, 6 years have been passed, my lord. The petitioner is in custody, my lord. Charges are framed 2 years back, my lord, in August 2024. And out of 92 witnesses, my lord, only 7 have been examined, and those all are, my lord, the formal witnesses. I mean, punch witnesses. And most of the accused persons, my lord, have been granted
We're
bail.
supposed to
my lord.
examine 40 witnesses because there are 4 eyewitnesses which will be examined next. Only punch witnesses have been examined.
Who denied you to examine, sir? Period of custody 5 years, 9 months,
Yes.
10 months.
Yes.
By this time, and you see, total his role is not specifically specified.
Yes, ma'am.
Unlike no specific role has been assigned. Cause of death is assault by means of assault. So what we can do now in such a situation? What we can do, sir?
That's in the supplementary statement, because the complainant said that he had a sword. Well, there are 53 injuries. This,
Maybe, sir.
yes.
But at present, what we can do? When considering the fact that no specific role has been alleged except to say, except to make some improve the statement in subsequently by the complainant. Full stop. In addition, the period of custody is more than 5 years and 10 months. And by this time, out of 92, only 7 witnesses have been examined. However, the delay in trial cannot be ruled out.
Only the trial may be expedited. No, this only direction trial may be expedited.
Will be expedited. Last trial will be expedited within a period of 2 years. 2 years. 2 years.
I'm grateful.
But the lordships are granting bail, my lord.
You don't want, sir?
I'm sorry. I could not hear that.
Grateful.
Great.
Lordship, in this matter, the petitioner was originally charged under 489B and 489C, and he was explicitly acquitted under 489B.
It is 489C.
Lordship, mere possession of the counterfeit notes. And Lordship, the state has already filed the counter. He has already undergone, Lordship, 1 year, 11 months, and almost 28 or 29 days. Lordship, fixed period.
2 years.
Almost 2 years, Lordship, and fixed
More than
period
2 years.
more than 2 years.
Out of 5 years, 2 years.
Please, Malos, out of 5 years, 2 years, Malos, she says that there is no antecedent. Subsequently, there is a gangster's FIR, Malos, with base offense, Malos, only under this section. Has been
Lordship,
registered.
which was invoked subsequently after the sole case.
After hearing and a complete certification and considering this fact, the conviction of the appealant is only under section 489C of the IPC, acquitting on the charge of section 498,
489B.
489B and 489.
489B, he was acquitted, and 489C survived.
Listen, thus out of total sentence of 5 years, 2 years has already been served. ऊपर वाला टाइम 2 years has already been served. In such circumstances, without expressing any opinion, subject to final outcome of the appeal, pending before the High Court, the substantive jail sentence.
Grateful, Lordship.
Please, Your Lordship. Milords, the state has filed counter, Milord. The charges are yet to be framed. All the other accused who have been attributed the role of stabbing have been granted bail, Milord. There are 47 witnesses, 14 material objects, Milord. Charges still not framed, and I've been inside for 3 years, 3 months now, Milord. Milord, the stab injury has been at.
Lordship, they have been on bail. One of the accused is now absconding. So the trial court has issued non-bailable warrants against him. This is the main reason why the charges are not framed. So, and he is not, he is specifically named in FIR, but I agree that all the other accused are on bail, but the delay is attributed to the accused persons who are on bail.
The role of this man is of stabbing by means of knife over the chest.
Yes.
The statement indicates that everyone who has been granted bail has.
No, it is not like
Milords, I'll read the sub.
Everyone who is granted bail, they also stabbed by means of knife, but on the back side.
Milords, I'll just read Milords supplementary statement at page 34, Milords. In fact, Milords, the death occurred after 30 days of the Milords, during the course of the treatment, Milords. He died after 30 days. Kindly have page 34, Milords.
Yes, sir.
Lordship, I'll leave it at that. He is the prime accused, but there is delay in framing of charge. The reason I tried to
25 to 30 days death is.
Lordship,
So you can understand what may possibility. We don't want say now custody is more than 2 years and by this time is 5 months.
Yes, sir.
2 years, 3 years.
3 years.
3 years.
What can we do?
Lordship, my only request that he should cooperate with the trial because the other accused are not cooperating.
So he will appear without leave.
And
he will not go.
yes, and Lordship may expedite the trial also. One line will.
After hearing the evidence for the parties of claim. Considering claim 3 point, though the rule has been assigned of assault to the accused. However, the death of the injured was after 25 to 30 days. By this time, the custody is more than 3 years and 5 months. Full stop. The charges have not yet been framed. Considering all these circumstances without expressing an intellectual obligation.
Very grateful, Milords. Very grateful.
Please, madam.
Yes, sir.
Counter could not place on record, but I have the physical copy. If my lord may permit, I can extend it.
Yes, what is there? What is there, please? This is of. We'll take it during vacation, you'll be, then they come to, during vacation. It will be placed on record list during vacation.
Please.
Yes.
My lord, pre-arrest, my lord, dismissed by the session judge, allowed by the High Court, only on the ground that the evidence is documentary in nature. Your lordship will just see the FIR for a minute.
Yes.
And the second point ultimately is, my lord, he does not disclose his criminal antecedents. But before that, please see the FIR, my lord, at page 30. And if I may invite your lordship's attention to, my lord, middle of that page, somewhere it starts subsequent to the completion. Lordship has, my lord, para number 12, right in the middle of para number 12, subsequent to the completion of the auction process.
Why we should interfere in this?
Lord, because
case which is based on a documentary evidence.
it is not, my lord, because I am the liquidator.
Yes.
My lord, I find out that 54 acres of land has been taken over by the
Maybe
government.
whatever
He
it is,
receives the money.
Whatever it is.
My lord, he receives the money. He is not in charge of the company. He receives the money. He pockets it, all of it. My lord, we don't know where the trail of money has gone. And secondly, my lord, he does not disclose his criminal antecedents. There is a public fraud of 306 crores by him.
Yes.
So, my lord,
My lords, I am appearing on behalf of the state, my lords, on advance notice.
Somebody is for accused. Issue notice
Grateful.
to respondent number. One. To and to accept notice on behalf of respondent number 2. Mr. Return negative in 4 weeks.
Grateful, man.
Your Lordship, I'm appearing for the petitioner. At the time of the commission of the alleged offence, the petitioner was 7 years and 7 months old. And Your Lordship, the name of the petitioner is neither in the FIR.
Lordship, the petitioner is in jail under section 20B subclause C and 25 and 29 of NDPS Act.
What is your period of custody by this time?
It's 10 months, 4 days.
It is too early.
Lordship, my submission is the petitioner has been falsely implicated, which is apparent on record. I can show before your Lordship. Lordship, the petitioner had started his journey from Lucknow to Sambalpur in Odisha, and he was returning back in vehicle number UP 32 HJ 9999. This was his vehicle which he was driving. He was a driver.
What is the proof of this?
Lordship, I have annexed the FIR and the charge sheet which Lucknow police has filed.
That is just a plea to take a plea of LIV. You have done all this.
Lordship, my submission is from the very beginning. I was driving this vehicle itself.
It's too early, sir.
Lordship, in fact, the Lucknow police has.
It's too early.
Lordship, my submission is that this is the clear case. Two more cases, Lordship. They have not complied provision of 105 of BNSS. No audio videography. Nothing. Even the seizure memo which was prepared, Lordship.
The quantity is coming to 131.5 kg of ganja.
Two vehicles. It was 87 kg.
This is just a nothing.
One submission, Lordship.
Yes, please.
They have prepared. They say that they have prepared the seizure memo on the spot. It is halfly in typed memo and halfly in a handwritten memo.
At present, we can't do all these things.
Lordship, but the submission is I was not driving this vehicle at all, Lordship. This is my submission.
We have put a first question to you.
Lordship.
What is the proof? So you can say that document. That document is a LIB only for the. We have seen that.
Lordship.
Nothing. Please see. After hearing. At present, we are not inclined to.
Lordship, at this stage, it might kind of.
We are saying at present, we are not inclined to entertain the present itself according to dismissed. However, after serving about 9 months, the petitioner is at liberty to apply for High Court.
Much obliged.
Please, my lords. My lords, the only piece of evidence against the petitioner is the oral testimony of the owner of the godown, my lords.
More is required. Yes, sir. What more is required, sir? Oral testimony.
My lords, but there is no rent agreement, no rent receipt. The co-convict who was apprehended at the spot, he has been granted the suspension by the High Court, my lords. Against me, there is the only oral testimony of the owner. Moreover, he has not proved that he was the owner also, my lords. No sale deed, no rent agreement.
Occupant of that premises where the recovery has been made.
Please,
and now only period of custody 2 years and 10 months out of 20 years of the sentence. We can understand if you have some minimum of 5 to 6 years, we can understand.
But
Because
there
the
is no
sentence
recovery.
may be reduced from 20 years to something. But for all angle, this is not a case to grant a suspension of sentence.
But there is no recovery from the petitioner and
Not a case in which the suspension of sentence can be granted.
my lord, that is
Yes.
there, my lord.
At present, we are
But
not.
then I will withdraw at this stage, my lords.
At this stage, counsel for the petitioner seeks permission to withdraw. Yes.
There is a letter, sir. Your Lordship, I'm seeking adjournment. There is a letter circulated. On the arguing counsel is not well.
Ajay,
Arguing
you
counsel.
are well? You are well or not well? Ajay? Are you well or not?
I'm well.
I'm well, then make your submission, sir.
Your Lordship, I'm.
Make your submissions. So and so, are you accepting, madam?
Yes, Your Lordship.
So and so accept notice counter will file within 4 days. Yes.
Obliged.
Yes.
Please note, this is an anticipatory bail, my lords. I was implicated solely on the basis of disclosure statement. I was implicated solely on the basis of disclosure statement. I was not named in the FIR. No role or overt act has been attributed to me, my lords. No recovery has been effected from me. And most importantly, my lords, High Court and Sessions Court wrongly observed that canter vehicle in which kettles were there. I was following that canter vehicle in my Brezza car.
You were doing since January 24. What you were doing?
Lords, I can only say I was not advised in the time.
Now rightly advised. Huh? While rightly advising, have you not asked this question?
Hold on, my lords.
Lord, charge sheet is filed against Lord 5 accused person. Investigation against him is pending. And Lord, page 36, the FIR, his name is Lord there, that he absconded from the place of occurrence.
There is nowhere mentioned, my lords, I was absconding or
There's one
evading.
more submission, my Lord. There is.
Please answer. That is the first question to you.
Hold on, my lords.
January 24. Now we are in May 26. Where you were? Person want to take a benefit of the anticipatory bail must come with this all clean hands. So, after hearing when it comes for the petition, we are not inclined to grant the pre-arrest bail as to it for by the petition. according to this.
See, well, the man is in the hospital. He was to undergo angioplasty on 20th May. But because of the pulse being too low, he has not been able to undergo the procedure. And the High Court has directed him to surrender today. Now, even if the angioplasty had been done on 20th May, he needs time to recuperate. Please have the impugned order. The order is of 15th May 2026. Medical documents have been verified. I suffered a heart attack on 16th of April.
Because he
I'm in
was
the
to
hospital
undergo
right now.
angiography, not angioplasty. The angiography, let the angiography report come, my lord. If the reports indicate something, well, it's only a outdoor procedure, my lord. It's not required hospitalization, my lord. Let that report come, my lord. If the report indicates that something for which he requires hospitalization, we will not insist for his.
You did angiography?
Sorry, beloved.
It was to be taken on 20.
Angiography done or not there?
No,
Not
it
done.
is not yet done. He is in the hospital right now. Well, may I have a humble prayer. I'll surrender on 30th of June.
Judge, who told you that you should not go for angiography? We can understand if angiography done and the blockage were there, then angioplasty did, then we can understand you can ask for 2 weeks further bail. But
Yes.
why at this stage? Why you have not done angiography on 20th of May?
Well, because the pulse is very low. He's currently in the hospital. Well, I have a humble submission.
Surrender.
Well, after
Otherwise
all,
they will take care.
well, as against 20 years, I have undergone 8 years in jail. The prosecutrix is not appearing in the court. The appeal cannot be heard. All I am saying is, I'll surrender on 30th of June.
You did
Whatever may happen.
whatever the procedure you do within 2 weeks. Otherwise
Very well, very well, very well, very well. Grateful,
Lord.
Grateful, grateful.
The net counsel for the petitioner and extremist yes. But the petitioner has to undergo the angiography, which could not be done on 19th and 20th of May 26. Since the pulse was low.
Please.
Please stop. However, considering the facts and circumstances of the case, the director and the petitioner is at liberty to undergo the procedure within 2 weeks.
Please.
Otherwise, he has to surrender
Please.
or not before 10th of May, 10th of June.
Yes.
Full stop. Yeah. Full stop.
No, please.
With the aforesaid observation and interim protection till the date as specified. The present as said, please stand disposed of.
Please. Grateful, my lord. Grateful.
For Dalgan and out of an order to
Those item 18 belongs to a batch of RSCP members.
RSCP के जो बैच किया है ना
8 to 6.
केवल टैग करना only delay is of 11142 only tag.
Item 19. Lordship, in this matter, the High Court on 1st of September granted issued notice, and thereafter on the 6th of October they asked for instructions from the private respondents as well as the NPCL. But later on the 14th November they dismissed it, saying that the only added parties are private respondents, and hence no writ petition is liable. Lordship, may please come to page number 57 for a moment. Lordship, bottom fourth line. The Electricity Ombudsman directed the NPCL, the public sector company, to observe the directions of UP Electricity Code, and thereafter we approached the writ against the NPCL only. And High Court after 2 days says it is not maintainable despite issuing the notice and asking for directions from the respondents.
Delay condone is to vote.
Obliged. Please, not in this case, not the Honorable High Court has relied upon a judgment in Mega case. That has been referred to a larger bench. If Lordship may permit, I can pass it on. Not the.
Very
Please, no.
Your Lordships. Your Lordship, in this, my lords, there's a dispute between the my lords, members of the my lords, one society, my lords. There are 5 buildings, my lords. 1 and 2, my lords, got acquired, my lords. They have got their compensation for the land and the flat also, my lords. Now, my lords, they are now again, after receiving those compensation, my lords, they are saying that the remaining land should be divided and that the new body has to be
What is
formed.
wrong in this? Bifurcation is permitted.
My only
Section
submission.
17 and 18. What is wrong in this?
Malus, what is happening is this, Malus, that the Malus, the remaining land is Malus have the compensation be distributed again amongst the society members, the whole as a whole, because the land belongs to the Malus, the fundamentalist of the society as
No, it
admitted.
is not a case. This may simply see the case whether bifurcation is done is right or not.
Correct, Malus. So Malus, the
bifurcation,
Malus, the deputy.
Under the statute, the bifurcation is permitted.
Correct, Malus.
So whatever the amount you can proceed, you can receive the whatever the proceed from that bifurcation.
Malus,
But how you can object of it?
Malus, bifurcation is after date compensation has been received Malus earlier, Malus. Now Malus, one set of members of building 1 and 2 and after receiving the compensation is coming.
Liz, if I may assist your lordship, as my
Not denied to assist.
Liz,
You can do it. What you will assist now?
Liz, I only invite the honorable court's attention to P7 for a moment. Liz, I just want to show 2 lines from that. It's
Yes.
P7 at page 126. Liz, it's an indemnity bond cum consent agreement given by the flat owners. Page 126, Liz, middle of the page, second last para, where it says executes this indemnity bond. The next para, explain to us the benefits of the consent award. In view of all this information, we have been informed that the estimated market value of land and building therein as rupees so and so of the said property, out of which the land compensation comes as rupees so and so. Let's may kindly come to the next page, Mulaz. I'm so sorry, 128, Mulaz, para 9 of this. Page 128, para 9, we will never claim additional compensation under section 64 of the Acquisition Act. Also, we do not rely on the terms mentioned in other courts. We guarantee in writing that the flat owners, our heir, will not file any appeal against the decision regarding the acquisition of the property. Now, my submission is this. Once they have received the entire compensation, including the land as per their own consent agreement, do they have any remainder right in the land which belongs to the society? And that fact is not disputed.
Malus, there is a Malus delay, Malus.
Delay condone.
Please.
So there is otherwise way to bypass the orders of this court.
No, my lords.
Oh, this is the way.
No, my lords.
No, sorry.
I'm sorry, my lords.
No, sorry, sir. You see the order. What
Please.
order we have passed?
Please, my lords. Last order, my lords have directed that the entire list be prepared on merits.
Yes.
Only to the remaining seats.
Yes.
So I will
So
be
now
affected.
after coming, you wake up and you come here.
My lords have said that
we can't
those
do it,
those persons
nothing can't do
who have
anything,
been before the High
We have
Court
not opened the Pandora box.
and those people whose petitions have been
No, sir.
dismissed.
We have not
Lords.
opened the Pandora box for anyone.
Lords, kindly see.
No reason.
This
Either
is
you
the-
withdraw, you
this is
want wherever you want to go, go. But here we will not entertain such petitions.
My lords, my only.
We see no reason.
My lords, allow me to withdraw that.
Yes, thank you.
Allow me to withdraw that
Senate Council 6
with liberty to avail available remedies.
present state petition with liberty to take recourse as punishment. Dismiss.
Obliged. Obliged.
My lord, in this case, these petitioners are selected way back in 2018. My lord, as per the qualification prescribed in the advertisement. My lord, their writ petitions allowed by learned single judge. My lord, now division bench remands the matter back, my lord, because after Supreme Court, my lord, there are two orders which are passed by the Supreme Court. My lord, one of the case, my lord, the Supreme Court remanded the matter back, my lord, to the High Court. And again, my lord, matter has been decided by holding they have a valid qualification. My lord, now since 2018, now, my lord, now they are made a shuttlecock between, my lord, single bench and division bench. The matter stands concluded. I request that the matter may not be immediately sent to single bench, so we'll decide. That's my request.
Let it notice, we will fix a date in the last week of July, then we will.
All right, great.
Notice on stay also.
May it please your lordship. My lord, I have served 23 years and the single judge has correctly directed my lord regularization. Again and again, there have been number of people, my lord, they have like, there are vacancies of 13, 12 are regularized. I am the only one indiscriminated against. And what does the High Court say, my lord? It says, my lord, may I request stay of the order also, my lord?
I beg to appear for the caveat, first respondent caveat. My lordship may make my submission. He was relieved on 13/4/2026. Yes, ma'am.
Are you working?
Not on merits,
I'm
he has
working
been relieved on 13/4/2026. Therefore, there may not be any stay, we will file our count.
Mr. Satyanarayan, in the
Yes,
meantime,
ma'am.
the improved order shall remain stay.
My lord, there is a small delay in refiling, my lord. Deeply obliged.
Deeply obliged.
Lord, the petitioner was suspended with during the roles, Lord, without opportunity of hearing. Lord, for the period, Lord, he joined the services, Lord, on 20.
What can be done?
Lord, the petitioner joined on 20th of August, Lord, 2000.
Whatever it is, sir.
But Lord, the suspension order has been passed. There was the rules, Lord, without opportunity of hearing.
How suspension can be required?
But Lord, the rules provides that
even need not to issue a notice, sir, for suspension. And
Lord,
High Court has
Lord,
dealt with
they issued the notice, but it was not served, and immediately I submit my reply on the next day.
Anything else? Thank you.
Obliged.
No reason.
Please. It's my VRS scheme specifically stipulates, millets. On 4th of November, I have issued the notice, millets, circulated the scheme. On 7th of November, I said that increment is not available.
Delay control issue.
Millets, lordship may stay the. They are filing contempt, millets. They are filing contempt.
Let file, then you can ask then at that time.
Lordship,
It will present, sir.
Much.
That is the High Court. On one hand, Lord, they directed that there is no infirmity in the order passed by the tribunal. Then the High Court has said that the Tribunal has rightly directed to engage forth with Milord. But in the concluding parameter, Lordship High Court has said that whenever the vacancy will arise, Lord. As per the seniority list, Lord, I am running from, I am a poor person.
Questions. 2-3 questions to you. Can we ask?
Yep.
We are audible to you.
Yes.
You were selected, you were within the list of the 12 persons of selected.
Yes, yes, Lordship.
9 verification done, 3 verification not done, you fall within 3.
Yes, I am also one of them. Police verification was not done.
Please listen.
Yes.
Please listen.
I'm sorry, madam.
Out of these 12,
Yes.
9 verified. So if we see the list of 12, what is your position in the merit in that 12?
Yes, madam.
Is it 9 were those who is from sequence 1 to 9, or 9 were those who is sequence 1 to 12? Out of them, some of them was there, and you are the person who fall within any of the person who is above than you.
You also, but
you have not taken no such plea like this.
The High Court said.
Can you understand our query, sir?
Yes, yes.
What is our query? If out of 12, if below 2 you have been appointed from that merit, then you may have a very good case, we can understand. No pleadings are this like this. Nothing is there. Neither the reply is there to that effect. Petition, then we will consider. But please come with a proper case, sir.
Then the liberty may be given so that I will place
Additional
the.
praise for him granted. 2 weeks time to file the additional affidavit and documents.
Obliged, deeply obliged.
After this.
Obliged.
Your Lordship, 28 has been dismissed on grounds of delay, Your
What
Lordship.
is wrong?
There is.
How much delay was there?
There was 388 days delay, Your Lordship.
388
However, Your Lordship,
period of limitation was?
writ appeal, Your Lordship.
Writ appeal, what is the period of limitation prescribed?
Your Lordship, 30 days.
Then what is the reason of prescribing a minimum limitation?
Your Lordship,
Because from one court you have to go to another court.
Your
You are
Lordship,
representing in one court, you have to go in another court with a representation. And you are at 388 days of delay.
Your Lordship, meanwhile, we have implemented the order. The High Court passed 2 directions, Your Lordship. One,
And implemented, then why
Your
you are
Lordship,
here?
there is a difficulty, Your Lordship. The High Court asked us to appoint the less meritorious petitioner who was before the High Court, Your Lordship, and also accommodate the other candidate, Your Lordship. Now, there are no vacancies, Your Lordship. We have implemented the directions of the High Court only with respect
What is
to
the date of implementation of those directions?
11th June 2025, Your Lordship.
What is the date of filing of this WA?
5th December, Your Lordship.
Why have you, while appointing, have you taken any pretext? Have you mentioned in their orders that we are issuing the orders of appointment subject to outcome to which we are taking recourse for filing of the writ appeal?
Your Lordship, we are not may I please we are not challenging his appointment, Your Lordship. Here there are 2 directions, Your Lordship. One was to appoint the petitioner. We have appointed the petitioner. The other direction was to accommodate the other candidate as well, Your Lordship. Our challenge is limited to accommodating the other candidate as there is no vacancy, Your Lordship.
Appearing on behalf of the petitioner submits that the order qua the petitioner in the case petitioner before the High Court in the case before the High Court has been implemented. However, the direction issued to accommodate other persons is under failure. It is urged that the writ appeal challenging such direction was filed with some delay. After implementation of the order for the petitioner complying the order of the High Court. Full stop. Therefore, to such extent, full stop. Considering the aforesaid, issue notice.
I am obliged, Lord.
So I'm sorry, however, the writ appeal was dismissed on the ground of the
Lord, in this case, though against the same order, notice has already been issued and status quo is there. 83 OAs were filed. They only filed 5 writs in the High Court. Though in only 5 cases, judgment was reversed. Our case, they never challenged. Now, on the basis of that, they have started issuing show cause notices to us. So, therefore, we have filed this SLP challenging that judgment with permission to file SL. Otherwise, on
issue notice. In the meantime, status quo है, permission का कर देना, permission का issue notice. इसके साथ tag कर देना. In the meantime, status quo exists.
My lord, they have issued further proceedings in pursuance to the show cause notice may kindly be
We
stated.
are saying status quo
As it exists.
as it exists today.
All. My lord, there is a 92 days delay because we had permission to file. And permission your lordship will have to allow.
With everything.
All right.
Anything else, sir?
No, that's all. Great.
Please, madam.
Yadav sir,
Please, madam.
delay. You have to dismiss on the ground of delay.
Lordship, at least your lordship kindly consider everything considered by the learned tribunal as well as honorable high court in lower side.
Do sir, you were sleeping over
But
418 days of
they
delay.
are very poor people, your lordship. Even
Poor
I'm yes, your lordship.
Poor
Very
people?
poor people. Therefore, your lordship, they are not in position to knock the door, your lordship.
What is the salary calculated for you?
10,000, your lordship. That has not been
No,
considered.
sir, that is the basic problem. You kindly look into the judgment.
Please, kindly, your lordship, consider.
Would you waive this interest? Would you waive the interest for this period?
Yes, your lord.
Huh?
Wait. I will leave it,
The
your
State
lordship.
Council for the petitioner submits that he is ready to waive the interest for a period of delay.
Please.
In case the enhancement is granted by this court. Full stop. We take the said statement on record. Full stop. Issue notice
File it.
on delay as well as.
My lordship, in this matter, we circulated adjournment letter. Grateful.
Or in this case, may I invite your lordship's kind attention to page 52.
State Council first. Call State Council.
Hello.
State of UP के वकील को बुलाइए.
So this need to be checked, my lords.
Notice check करें. पीछे लगा.
Deep to obligement.
There is a letter.
Lordship, I'm requesting for a passover, the main counsel is on the other courts.
My lord, there are glaring inconsistencies, my lords, in the statements of the PW2, my lords.
Yeah.
PW2, 3 and 4, my lords.
Yeah.
PW2, my lords, may I read, my lords? A1 took me to the kitchen, removed his clothes as well as the midi I was wearing at the time and sat on the top of me, rubbed his genital organ over my genital organ for some time. After about 5 minutes, he got up and left the place. When I was in the I've been in custody, it's been more than 12 years.
Issue notice. Delay convert. Issue notice. On merit as well as full sentence.
Obliged, my lords.
Both.
Obliged.
Come with instruction.
Grateful.
Go by the old provision, unamended provision.
These are the old provisions, my lords. Offenses of 2012. I'm grateful, my lords.
That will go till sentence under one.
Please, my lords.
Next day we'll.
Obliged, my lords.
Here, this is delay of 132 days. Delay. Now, the petitioner has clearly stated in his FIR and as well as in 163 statement the involvement of all the respondent matter, accused persons. The High Court also observed that at page number 5, Miller, paragraph 8, no doubt, as rightly confirmed by the learned counsel appearing by petitioner in his complaint as well as in the statement under 161 CRPC has implicated the involvement of the respondent 3 and 5. Moreover, at the time of his admission in the hospital, he has stated before the medical officer that he was attacked by 4 respondent. And the petitioner has clearly attributed all the overt act of the respondent, my lord. He is 72 years old. In all the records, my lord. Kindly page number 19, my action register is there.
Really condone issue.
Stay, my lord. The trial is going on trial.
What we can do, sir, at present, without hearing, it's a case of a discharge.
Yes.
Then what we can do? Let us come. Let them come. We will consider. We'll consider.
Oblige.
My lord, the order passed by the Honorable High Court is absolutely ill-reasoned order, my lord. My lord, may kindly see page 10, paragraph 15. No reason,
no allegation.
no reasoning, my lord.
No allegation, madam.
My lord, may kindly see. My lord, may kindly see the FIR.
Don't put every family.
My lord, there is no question of. My lord, after the marriage, the husband left for Germany, my lord, for 1.5 months. The wife used to stay with the in-laws, my lord. There are not only
between that period of in-laws? No.
Yes, my lord. There,
No.
my lord.
That period, no.
May I read the?
Kindly read.
Yes.
You read.
Yes,
You
page,
read for yourself, ma'am,
yes.
please.
Page 33 is the FIR.
Kindly read. We are not denying of anything, madam.
Yes, my lord. And page 37 is the FIR statement.
Nothing is in the FIR. When the statements come, then you started alleging everyone.
My lord, no, it's not correct, my lord. My lord, page 37. Page 37 for a moment.
These poor fellows, eh?
My lord,
nothing is there.
my lord, but what is the reasoning given by the Honorable High Court? Absolute, my lord, I'll just read one paragraph given by the Honorable High Court, my lord.
Thank you, madam.
Which are the facts and circumstances of the
Thank you,
case?
madam.
Not even a single.
Thank you, madam. Thank you.
Oblige, my lord.
Yes.
Well, despite the claim and counter-claim of both the parties, my lord, the supurdagi and custody was given to the complainant beyond the purview of 451 because there is no ownership. Moment, my lord, we say that the property ownership is already attached. It is admitted case that part of money is paid. So moment is admitted by the seller that part of the pay is paid and the rest of check could not be placed on record and for the bank encashment. So right gay included, my lord. My lord, accused.
Yes.
I'm saying accused, but
Yes.
ownership right is intact with that. I have paid the money. It's an admitted case.
All directions have been issued. All security.
But my lord,
arrangements have been checked by the court.
admittedly, this gold is 5.80, and the valuation was done by below the 3.6, and this Suburdiginama was filled for 3.6. Then all the money, I am saying that it is my family ornament, my lord. And why? I am ready for joint possession, no issue. Even trial court, but not to be the complainant. Indirectly, it is given that Supurdagi to the complainant. Complainant has no ownership. Complainant himself is saying that my money is not paid fully. That is the only grievance, my lord. When there is no ownership, only the right have the recovery only. They can recover the money by any way. This is settlement of account, my lord.
This is one of the way. Thereby they need not to go for recovery proceedings, and they will satisfy by this.
Well, maybe recovery, but my lord, 451 is says that ownership is right. I have this is my ornament, my lord. Then it may be joint possession. I have no issue, my lord. Possession has been given to the complainant, and the supervision is given to some banks. Where I am, my lord.
Nothing is there.
At least my joint possession may be given.
Nothing can.
Well, right to respect may be given, my lord. Anything may be given.
Sir, nothing, sir, in this case.
Great.
Lords, I'm yet to obtain instructions, my lords. We tried to contact him. He's paralysis patient. So, my lords, I am awaiting. My lords, I'm awaiting instructions, my lords. We have not been able to contact him. My lords, I'm for the respondent. My lords, he's a paralysis patient. May have it, my lords, after vacations.
My lords, this is probably a matter where, my lords, the railway had to file a status report. I think my colleague is mentioning some other item, item 40.
No, this very matter, my lords. I
One
am.
issue is there in this case.
Item.
Madam, Sarya,
Yes, my lords.
there is one issue.
Yes, my lords.
Railway is relying upon some report of 11/7/2016.
Yes, my lords.
That is of the CBC report.
That's
But
right.
the final report of the CBC we have quoted in our order.
My lords, then your lordships had modified the order, my lords.
Satisfied to us that 16 report and the final report
Yes, my lords.
is which we quoted
Yes, my
in
lords.
our order.
Yes,
So
my lords.
suppose subsequent report is there, final report, wherein some action has to be taken, then how you can rely upon some interim report of the CBC?
No, my lords, your lordships had
So better
modified.
in this matter. So better is you may also look into this.
Please,
The other side may also be noticed. Then we will look into.
please, my lords.
Which is report received from the IRCTC by the office of the list for orders. By the Pradeep Rade, Deputy Chief Vigilance Officer, Central Railway, has been placed for orders in furtherance to the previous order. In furtherance, indicating the compliance of the main order dated so and so 21/1/25 past 5 this court in criminal, especially criminal numbers bench. Full stop. This case it is required to be looked into that in para 3 in the final order the observations made by the CBC in the report has been quoted. However, the action taken report is based on the interim report of the CBC dated 11/7/2016. Full stop. Learned ASC may look into all these facts and apprise on the next day. Full stop. The so and so petitioner be noticed in the meantime. Respondent be noticed in the meantime. Respondent of the original case, original SL criminal number so and so be noticed in the meantime. Full stop. List after 6 weeks for further orders.
Obligement.
Please. No, apart from Niharika, where your lordship has said that the investigation should not be interdicted. Just have a look at the false statements in court. Let's just see, look at page para 4 of the impugned order.
Go there, yes, sir. You go there and
Just have a look at it, minutes.
You go there and apply to the High Court, sir.
Just have a look at it, minutes. I'll just show minutes what is happening.
Yes.
Just see, because this is the order passed after hearing me. Just see this. Para 4. The allegation is that
Dalal submits.
Mr. Dalal submits that subsequently, in order to clear the existing loan against the subject property, the petitioner cleared the dues owed to the HDFC Bank and obtained no due certificate on 27/3/26. That is subsequent to the FIR. Now, just have a look at page 29.
Yes, sir.
That was in relation to some other property.
Yes.
Page 29. Lordship, just see this at the second paragraph.
This document was filed by you before the High
No,
Court.
no, this was filed by them before the High Court along with the writ petition.
Go and point out this. To the High Court.
And just one more thing. Just have a look at this because this says.
Yes, sir. Yes, sir. All this we are not saying anything against you.
Yes, ma'am.
What we are saying is arising out of an interim order.
Yes.
The material which has been placed before us
Yes.
may be brought to the notice before the High Court while applying for modification of this order. But the High Court may look into on the merit of all these contentions and pass appropriate orders.
And one more
Not
fact.
saying anything more, sir.
There's one more fact.
You have to go for more facts. You go show more facts to there.
On the face of it, it is like that. Lordship, may clarify.
Rising out of an order. 16th of 2026. Passed by the High Court. issuing interim direction. In particular, para 13 for the case, the present petition has been filed. The present SLP has been filed. And the senior counsel has shown various documents indicating the fact that the consideration as made by the High Court. Consideration made by the High Court is not without looking into the document connected to those contentions. However, at present, we are not inclined to entertain the SLP and grant liberty to the petitioner to file appropriate application for modification of the order, modification of the vacation of the order. Yes. Before the High Court, along with the relevant documents. 11 reading and documents. List upon filing such application, the High Court, affording an opportunity to the other side to pass appropriate order. First of all, with the aforesaid order, with the aforesaid observation, present SLP stands disposed.
Great.
42.
Milords, by an unreasoned order, Milords, the whole trial has been stayed, Milords, against all accused. Only one accused has filed a petition against framing of charges, and the whole trial has been stayed, Milords. And this accused, Milords, filed a discharge, which was dismissed. And then she has filed an application against framing of charges. And Milords, no reason whatsoever. Both the parties appeared before the High Court, Milords. Arguments were advanced. No reason is given why it has been stayed, Milords.
Apply there before High Court.
Because practically, trial has already been stayed.
Practically, we are not saying anything. We are only saying practically you go there and apply because.
Milords, I'll do that. Milords may pass that.
Against the SLP, it's against the interim order. However, at present, we are not entertaining this bill. It suffice to say that if petitioner applies vacation of such an order, the High Court may consider the same, affording an opportunity to other side. Dispose of the opportunity.
Milords, one request, vacation stroke modification, if Milords may write, because there might be a
modification of the vacation.
Oblige.
Wait, please, Lords. Lords, I appear in this matter, my Lord. The petitioner in person, my Lords, were gracious enough to appoint me as the amicus on 27/1/26. My Lord, this is a miscellaneous application which has been moved for restoration.
Yes.
For restoration, my Lords, the restoration application, my Lords, MA was moved on 13/2/2024 of an order dated 8/10/2018.
Surprise to your client.
My Lord.
What he is writing, the court is protecting their registrars.
My Lord,
Huh?
I have informed.
What is this, sir?
My Lords, I have informed. I have definitely, he's online, my Lords. I have informed, I have apprised him.
We do not afraid of anything, sir.
No, we bow down to that, my Lords. I have informed him. I have informed him thoroughly. I have informed him thoroughly, and I told him that this is not right.
Tell us why you cannot go in the High Court.
My Lord, the High Court matter, my Lords, which they had moved, there was a typographical error which I have explained to him. There was 15/16.
Cannot go in the High Court, sir.
No, High Court he moved, my Lords. He moved High Court. My Lords, he moved High Court. He moved High Court. After the High Court, my Lords, he filed a 32 saying that the High Court has incorrectly mentioned 2015 to 2016, which I explained to him.
Mr. Chopra,
My Lord.
does it make any difference to that?
My Lord, then I leave it to my Lord. I direct him to go to the High Court.
That we will hear him also. What do you want to say?
My Lord, he's there.
Yes, please. What do you want to say?
Yeah, actually, sir, the typographical error is acceptable. I leave to you, my lord.
Here in this case. And we are telling you, by the next time we will write like this, that we want to protect the registrars and everything. All right, registrar's function is completely different. The court function is completely different. This is completely merely on this statement. Your action must be, this should be thrown out.
Okay.
It is not like this. You are litigating since beginning. You have seen everything.
My Lord, in fact, I also pointed out
You
that.
were unsuccessful. And now alleging, pointing out a finger from to everyone. Introspect yourself, sir.
Because in fact, the MA itself has been moved after more than 100 to 272 days.
We are aware of this.
So that itself.
And how this MA can be entertainable? Tell us.
I agree, my lord.
Recently, we have said in one judgment.
Yes, I agree, my lord.
Justice Pardiwala said of this judgment.
My lord.
Circular issued by this court.
I agree, my lord. I'm to that. I'm informed that this MA is per se not maintainable after 1,000 days itself. How can this be moved also?
Nothing can be done, sir. Okay. After hearing the petitioner in person, as well as the amicus appointed by this court, they are not inclined to interfere in the proceedings. Full stop, dismissed accordingly. Nothing can be done.
My lord. I'm so obliged, my lord, for the opportunity, my lord. Thank you.
44. Yes, sir.
Is abrupt withdrawal. Sorry.
Since an award duty, I may accept it not tentative. See, वो judgment है ना अभी मेरा जो judgment है dismiss accordingly. लेकिन yes, sir.
Sir, the reason for filing this petition is for abrupt withdrawal of my video conferencing rights at Family Court, Motihari, Bihar, and second, non-supply of order sheet copy, digital order sheet copy. In reference to
Why
that,
you
I would like to point four.
Why you cannot go in High Court, sir?
Sir, because this is filed under Article 32, because my fundamental rights under
Have you
Article
read
14, 19,
Article
and
32,
21
sir?
has been hampered. Sorry, sir?
Have you read Article 32?
Yes, sir.
What is required in Article 32?
If the fundamental rights have been hampered, I can approach the
So
Supreme Court.
doesn't mean that every case must be entertained in Article 32, and that too is still matters like this.
Sir, this is a state matter, but the governance has to be through the Supreme Court itself.
Do not have
Because,
that much time to entertain such petitions. Would you like to go in?
sir, only two submissions
Sir,
from my side, sir.
You are asking, would you like to go in High Court? Otherwise, we will dismiss this.
Yes, sir, I would like to go
in High
but
Court.
only two submits, sir.
No, nothing doing. Okay, after hearing this
Sir,
petition,
at least.
we are not entertaining the petition Article 32. Please at liberty to approach the High Court.
Your Lordship, I am parting person. Page number 158, Your Lordship. Earlier, I have filed the writ petition, Your Lordship.
In 45.
158, Your Lordship. 158.
Yes.
So this is a writ petition I filed against the same order, Your Lordship.
Yes.
And which was dismissed on the ground of maintainability, Your Lordship.
Yes.
So now I filed a special leave petition, Your Lordship.
Yes.
Challenging the CAT order, Your Lordship.
Yes.
Your Lordship, why I have not gone to High Court means, Your Lordship, writ petition under Article 226 and 227 is not a appeal, Your Lordship. So I need a substantial appeal, Your Lordship.
Is it a appeal here?
Your Lordship?
Is it a appeal here?
Yes, Your Lordship. As a special leave, Your Lordship.
The special leave is not an appeal until the leave is granted.
After special leave is granted, it will be converted as a civil appeal,
Have
Your
you
Lordship.
compared with the provision and language of 136 as well as 226? Have you compared with the scope of 226 is larger or 136 is larger?
So 136 is larger as well as 226 is larger, Your Lordship.
In a cases where the orders have been passed by the tribunal, no scope larger than 226, 227. All right, 136 scope is only of leave. There you can go and address the court on the points. Here, until we grant the leave, you have no scope.
That's true, Your Lordship.
So go before High Court.
Your Lordship, kindly make a direction to that effect, Your Lordship.
We are not issuing any direction. You have a remedy available, you take a recourse as permissible under the law, not before us.
Your Lordship,
136 at present.
you will have, your Lordship, I will have to fight out with delay, Your Lordship. So kindly pass an order saying that.
No, we can't say anything. We are not saying you are taking a recourse even before this court with a delay of 291 days. Why we should condone once you have make a delay here?
Your Lordship, there is no delay, Your Lordship.
High Court may look into.
Your Lordship, I have clearly explained delay is not
They
really.
are not entertaining this SLP. Okay. Arising out of an order of the Central Administrative Tribunal dated 4/12/24. The petitioner is directly approached to this court. However, he is at liberty to take recourse as permissible. Full stop. There is a delay of 291 days also in filing of the SLP. Full stop. Considering all the aspects, we are not entertaining the SLP.
Lordship, I have a remedy of administrative review, Your Lordship. So I can
So
have
whatever
it.
you want to do, you can go for it. Order of the CAT and the order of review. Both dated 7th of August 2025.
My lord, 61 is a complaint case, my lord, where cognizance was only taken under 498A and 323 IPC, my lord. 498A is up to 3 years. So, for until and Ernest Kumar, I should be granted the benefit of anticipatory bail. I have no antecedent, my lord. But High Court has read the entire complaint as if 307 is made out against me and dismissed my anticipatory bail application, my lord.
What antecedent you want to do in this case? You want to go for a second marriage, then you will do
My lord,
harassment, then
we are paying maintenance also.
You want to do this?
We are
Antecedent, you want this?
no, my lord.
Then
Just making out a case for anticipatory. We are paying maintenance, my lord, and we are willing to live with the wife. Page 35 mediation has been failed, my lord.
I appear for the state.
see, you appear for this state,
State
just
as a
therefore
fresh
you are
matter.
asking.
It's a fresh matter, Your Lordship, and it's a complaint case. There is no investigation, Your Lordship.
Issue notice. 4 weeks. At this space, on behalf of the state, noticing accepted. Hence, the stop. Notice to issue to the complainant be sub. Since it is a complaint case, therefore complainant be served.
She's respondent number 2.
She's a
She's
respondent.
respondent number 2.
Complainant respond number 2. Please, sir. In the meantime, no coaching steps. It's a subject to court.
Great. please.
I'm great.
Great.
Lordship, in this matter, Lordship, only single adjournment I have taken the whole 2 years trial.
You are taking, sir.
Lordship, may kindly see the page number. In
Why
report,
taking adjournment, sir?
Lordship, only single adjournment. On dated
Now
4.
would you appear now every day?
Lordship, every day appearing on.
Can we record your statement that now you will appear on every day?
Lordship, I'll appear. Subject to exemption because I am 68 years old, medically challenged. So sometimes.
Sir, please, we are asking, would you appear regularly on every
Please,
day?
Lordship, please.
Again, let counsel for the petitioner has stated that it is a case in which merely asking an adjournment for a single day, the cancellation of the anticipatory bail has been directed. It is stated by him that the petitioner shall regularly appear in the proceeding until leave is granted by the person, considering the aforesaid. Issue notice. Stop. Notice on behalf of
The state.
is accepted.
Your Lordship, I am caveated for respond number 2.
1 and 2 is accepted. Who may file? Let me dispose of, madam, why this is unnecessary.
Please, your
Keep
Lord.
it pending for no reason, madam.
Please, Your Lordship.
One day he not appeared. Ask for adjournment. Court passed an order of cancellation of the bail.
No, Your Lordship, the reason was different, Your Lordship. He had disclosed.
We don't know what is different reason.
No, Your Lordship, the reason.
So now he will appear on every day. What is required, madam? It will delay everything.
Actually, Your Lordship, I thought.
Rising out of वो हटा दीजिए पूरा काटून. Notice is accepted by the respond number 1 and 2. Learned counsel appearing on behalf of so and so. Police by the consent of the parties, the division case.
Your Lordships, if I'm permitted to reply, Your Lordships, to my knowledge, I've not gone through the SLP because I just filed my. I'm sorry, Your Lordships.
Issue notice at this stage so and so accept notice. दोनों की तरफ से लिख लेंगे. You may file counter affidavit. In the meantime, operation of the order passed by the High Court shall remain stay, subject to appearance of the petitioner regularly during the.
Yeah, that's grateful.
Grateful. For the petitioner, the case for anticipatory bail. I am the owner of the vehicle and I had leased out the vehicle to these people. And that was used. And I would not shy away from pointing out that during the course of investigation, they say
Only
that.
one question to you.
Yes, Manoj.
And then you decide.
Yes, Manoj.
Page 38, para 7 of the lease agreement. You are aware of everything, eh?
No, Manoj, that's.
You are aware that this incident may happen. So therefore, if that would be done, he will not be responsible.
No, Manoj. One important. No, Manoj. I understand what is falling from Manoj. The problem is, Manoj, in Gujarat, if you lease out the vehicles.
Can you understand, sir?
I understand.
This can be written.
I understand. I understand, but
Sir,
but it's only liquor. It's not something greatly in some narco substances.
No, it's not a case.
Kindly consider only. It's a 6 months and 9 months imprisonment offence.
Whatever it is, sir. This is not a case. On filing of this document, even otherwise is not a case. We can understand. You will say, sir, you have seen this also.
Yes, Manoj.
Then you will point out.
No, Manoj, I was about.
See this. What is this? Para 7.
No, Manoj, para 7. I'll try and explain. Then, my lord, I'll just try and explain. Manoj, the problem is.
Everything.
No, generally the leased vehicles are used for all these things. That's why there was a precautionary.
You are also counsel, sir.
Yes.
Since last more than 35 years. Don't say this.
Grateful.
We understand everything.
Yes, Manoj.
With all equities, we are in favor of everyone. But if you go and making out a jalebi and MRT to us, sorry.
No, Manoj.
Don't do it.
Not even an attempt, Manoj. Not even an attempt, Manoj. But kindly just consider two aspects.
No reason to interfere. Nothing doing.
Obliged. Grateful.
Yes, my lords. My lords, the petition raises an interesting question of law. The communication involved is gratitude journal, which I have, wherein I pay gratitude for 5 good things that happen on the day. It will.
Notice, then we look at it. It's a point in the context of section
120, 22, my lords.
The BNS section.
BNS, indeed.
Because it is very material.
We
have seen that also.
My lords.
That. It's a point to be determined.
To be looked into. My lords, would it be possible to consider stay also? Because this exhibited is marked.
It's a gratitude general.
Indeed, gratitude. So it's to self and to individual.
Understand,
very
gratitude general, what do you mean?
Very well. The word itself is self-explanatory. My lords may consider if stay, my lords, because this has been exhibited, marked, and my cross-examination if the trial continues based on this document. And what is a veracity? This was taken 2 years back when he left the house. Suddenly it's come. Now what's a veracity of what he can add and change the tone of the entire complaint?
Still, you have to explain one thing more. You see the language.
Indeed, my lords.
Language of 122.
My lords.
Language of then there are evidence act then.
My lords. It's on page O of the SLP.
Yes, it is quoted.
Page O of the SLP, my lords. No person who is or has been married.
Yes, these
Shall
two words. Who is
or has been married.
You
Shall.
have to come prepared of this.
Very well, my lords. I'll get back on this.
To know this. Tell nobody. In 6 weeks. In the meantime, the further proceeding in trial. Give the court number and case.
Indeed, my lords.
So, shall remain stay till next day. This one date fix kariye.
Be grateful, my lords.
Pursuant to the caste certificate issued by the competent officer, my lords, SDO, I was appointed as a Ayurvedic medical officer, my lords. Now, my lords, I'm seeking no coercive action, my lords.
In the meantime, no coercive action.
Much obliged.
Accepting notice.
Much obliged.
Except for your counter be filed within a period of 6 weeks. Rejoin the
Rejoin.
2 weeks there.
Much obliged.
Deeply obliged.
Date may be fixed after 8 weeks.
Much obliged.
Please.
And for the my counter is there in the second.
I'm for the petitioner, my lords, in both the matters.
Yes.
Whereas the matter was sent to the mediation, my lord, but the respondent did not appear there, my lords.
No, your lordship, we were up here. I don't know why he's
I was,
taking this.
apologize, my lord. I was informed that respondent did not appear before the.
Yes, 66.
Yes.
Yes, 66.1. 138 matters, your lordship.
In another case.
Yes, your lordship. This is 138 matter only, your lordship. It's covered by your lordship's
You are
judgment.
for whom, madam?
I am for the respondent, your lordship, in both matters.
Respondent means?
Respondent company, Anabond, Mrs. Anabond
Why
Limited.
you file the case there?
Your lordship,
You have offices everywhere, na?
no, your lordship, our corporate office is at Chennai.
No,
And
maybe at Chennai, but this where this
that
check
is
was issued.
your lordship, the
Jabalpur, my lords.
Where?
your lordship,
Wait,
we,
Mr. Wait.
we have manufacturing units in all over India, and our corporate office is at Chennai, and we are in a uniform basis. We are.
Office doesn't mean your offices are situated everywhere.
No, your lordship, that's what we are saying. All the matters, our corporate office is at Chennai, and we have deposited the
Corporate office, we have understand, madam.
Yes, your lordship.
Or corporate office doesn't mean that every litigation would come there. It's a matter, simple matter of negotiable instruments act. Which office dealt with?
Your lordship.
Whether corporate office dealt with this negotiable instruments act case? No.
Your lordship, it's
The office who taken the check would deal with.
your lordship.
So why should not be transferred?
Only our manufacturing unit is at Jabalpur, your lordship.
No, madam.
And both the matters
It's just like a harassment.
No, your lordship, kindly see.
You can't permit the harassment in a court. At one occasion, court is going to the footstep of the person who is aggrieved. And the another way we do this thing. Which your office has been dealt with this issue of checks
Your
and
lordship,
everything transaction dated?
our main office is at Chennai only, and our corporate office is at Chennai only. The Jabalpur.
Not asking
Your lord,
said
your lordship,
times main office.
Your lordship, in
We are
Jabalpur.
asking which of your office has dealt with this loan transaction.
Your lordship, that's
Please
what
tell us
I'm
of this.
that's what I'm submitting, your lordship. The Jabalpur office only that manufacturing unit is there. We have manufacturing units all over India, and all the transactions
You
we are.
have your office in Jabalpur or not?
We have only our manufacturing unit and an office which controls the manufacturing.
Leave it, sir, madam ji. Judgments are there, but we have to look into this aspect. Where is your office? You kindly see the document at page number 19. Yes, your lordship. Everything is on Jabalpur. We did then asking you to come in Chennai, we have filed it. Your officer can, Jabalpur can handle it. Like we transfer this.
Lordship, Lordship, kindly see the judgments, your lordship. Sindur Akura, your lordship, your lordship, that. Your lordship, all the cases we are controlling from a corporate office itself, your lordship, after this COVID. Otherwise, it will be difficult for us also. All over India, we have to file in.
To you people. Yes, 67.
67,
Yes.
Respondents. You filed a counter affidavit saying that the charge sheet has been submitted, cognizance has been taken. And they're very close relatives. And number close relatives. I mean, and the old land dispute. And informant was not an eyewitness. And the last and the least point, Lordship, what I've said is the injury report, they show simple injuries, only grievous on the wrist. So, as if they say that the informant says that it was hammered with sickle and rod.
You are
And
for the complainant or you are for the state?
Milords, I am appearing for the state, Milords. Respondent number 1.
So I'm for the respondent.
I am appearing for the petitioner, my lord. I am appearing for the petitioner, my lord.
What is the nature of injury, learned state counsel?
Milords, injury number 2, your lordship will see injury number 1 and 3 are grievous in nature.
Which
Injury
is
number
we can gather this.
Lordship will come to the injury report, which is annexed as an extra CA1 at page 7 of my counter affidavit. An extra CA1 at page 7 of the counter affidavit, your lordship may kindly see.
Yes, sir.
May I read, Milords? Injury number 1 is bleeding from left ear, CT scan of brain advice. Injury number 3, laceration of 5 centimeters, etc. Margin on scalp left hand side. Now on the opinion aspect, Milords. Injury number 1 and injury number 3 is grievous in nature as CT from Bain plus diagnosis reveals hemorrhage, SH, intrapharyngeal hemorrhage, contusion and hairline fracture of
brain CT scan done.
Milords.
Is brain CT scan done?
Lordship.
Yes, your lordship. Brain CT scan is done. He was been admitted for last 2 months. Still, he cannot stand on his own feet.
Madam, would you
His
wait? Madam
femur
Sangeeta,
bone
for a
has been
minute.
broken. That is.
Madam Sangeeta, we are audible or not?
Yes, your lordship, you are audible, my lord.
Yes, Mr. Government Counsel, where is that CT scan? Bleeding from left ear, CT scan of brain advised.
Lordship.
Is it
And
any
Milords,
done?
Milords, he was advised because this is the medical report by the doctor, Milords. He was advised done, but
done, sir.
CT was not done at the instance of the state, Milords.
My lord, if my lord may kindly see main petition page number 11, my lord, there is a CT scan is there, my lord. Page number 10 and page number 11 of the main petition, my lord.
Yes, please.
Page number 10 and page number 11 of the main petition, my lord. The whole pelvis, if my lord may permit, I may. My lord, even the statement of the victims has not been recorded till date, my lord. He has been admitted for last 2 months, my lord. And the CT scan and the injury report suggest that whole pelvis bone has been broken by rod, my lord. Both hand were fractures, both pelvis, he cannot stand.
Charge sheet has been submitted in the meantime and cooperate with the investigation. Cognizance has been taken and trial is, Milords, on the way.
Sir, but
Number
it's
one.
not a case of anticipatory.
Number two, Milords, we are all very close brothers. Milords, they are cousins.
No.
Lordship.
Your,
Lordship.
there is
Just
open and,
no, they're
my lord, there is open and direct.
We are asking the other side, just wait.
Milords, they are all Fufera brothers, Milords, because of land dispute. And in the FIR, it has come that there's been an old land dispute, Milords. And number two, Milords, the injury weapon used was, Milords, it was saying sickle, rod, and knife. But they are all hard and blunt substance. Milords, you see in the injury report, page 7. And all the reports which she got was from private hospital, Milords. Number one, Milords. Well, I can compensate on that, Milords. She has given a bill of 1,50,000 rupees. But Lord, you would see the all, Milords, all the private documents, Milords, they're all private documents. The injury report of the government, Milords, would show that it's all by hard and blunt substance. Whereas in the FIR, it is nobody saw assaulting, Milords. Informant is a Pardhanashil lady. She
No, my
says
lord,
that
there are video
she was not there.
recording.
She was not there.
Evidences are there.
Says that my husband, I saw my
And my
husband.
lord, there
Everybody
are
is around.
eyewitnesses
Villagers had
who
come.
has to be
So he
examined. We
Madam
have
Sangeeta,
already moved an application for that, my lord.
Sangeeta, there is a manner in you have argued your case, you would wait. We are asking the other side, you are starting speaking. This is not good, ma'am, please. Wait.
Because in the FIR they've said, the translated copy, the above mentioned people started attacking my husband with a knife, rod and sickle.
Have you received these documents?
Well, yes, Milords. Those are all private.
Have you filed any counter document to this?
Okay, can I file that? Because they're private documents, Milords. Those are private, Lordship. I'm just submitting.
Doesn't mean that
What I'm
every day is going to the private hospitals also.
my lord, what I'm submitting, we also.
We can say the private hospital report is not correct.
My lord, what I'm.
The CT scan report of 12th June 25.
Milords. My lords.
All right.
My lord.
June 25.
My lord.
All right. It's a fracture over the head. It was advised by the government did not do it. Doesn't mean the person is admitted in the hospital and now this is certainly it is a dangerous to.
Well, what I'm submitting, Lordship, charge sheet is submitted, Milords. There's no investigation, there's no chance of custodial interrogation, Milords. I'll appear in the trial, Milords. Bind us down, Milords. Bind us down, Milords. I'll appear in the trial. The cognizance has been taken. Let the trial carry on, Milords. We will not, Milords, even be around them. Milords, there's a property going on, property dispute going on. Repeated.
Property dispute, there are courts available.
Courts are available, Milord. And they are planning to, Milord, I think they have filed civil suit also.
Property dispute, courts are available, the courts are permitted, courts are given.
Yes,
civil
Milord.
courts, criminal courts.
That is also going on, Milord.
Permitted to take the law in their hands.
Law in the hands in the sense, Milord, I have also suffered injuries. I did not, Milord, file FIR. They have filed FIR, Milord. Mischievous, we have suffered graver assault, but being a relative, we did not file, Milords. One of them has grievous injury, and one.
It has been filed.
Milords, charge sheet has been filed and cognizance has been taken, Milords.
So now it is in the court, madam. Any custodial interrogation is not required. What do you want to say?
My lord, I just want to say the first on the injury part, my lord. One
part is fine.
62-year-old person.
Injury part is fine.
Yes, my lord, there are
Like a
eyewitnesses who need to be examined. There is an open threat to all the witnesses, my lord. They can't. The police has even not recorded the statement of the victim, my lord, who has been hospitalized for more than 2 months. I have been given open threat to leave the village. Otherwise, you whole family, all female are there on one aged person. My son is studying outside.
I'll go outside.
Outside, you will not stay.
In fact, I'm outside
on
now.
One day, there is a
I am outside now.
statement of all the witness has to be recorded. There are eyewitnesses. Video recording, photographs are there, my lord.
Incidents took place.
A person whole femur bone,
This is
the
Jharkhand, Bihar,
backbone
small village
hole
in
has been
Jharkhand, Bihar.
broken by
Which
the
village?
rod. There is a major injury at the head. Both
Name of
hands have been
district Pakur,
fractured.
Bihar. Village Naya Farsa,
That has
district
been
Pakur.
operated,
District Pakur is
and that I
Bihar,
have.
near to Bengal. And they are all working in Bengal, Bihar. I
Sangeeta, you want to say?
In fact,
Madam Sangeeta, you want to say anything else? Okay.
yes,
Please tell us what you want.
yes, my lord. I just want to say that the statement of all the eyewitnesses has to be recorded. There are more than 8-9 eyewitnesses. Video recording has to be submitted. Statement of victim has to be recorded, my lord. And there is a complete apprehension of the threat of life, even for myself, for my younger daughters, and the person and the victim, my lord. The statement of victim has not been recorded. How they are going to give their statement before the court, in the court, my lord? Just an anticipatory bail on the first day in such a grievous injury, that age-old person, 62-year-old person who has been attacked by the rod and whose lower part has been broken, both hands have been fractured, and they are out, my lord. How the statement are going, how the witnesses are going to the court without any fear to record their statement, my lord?
We will consider. Who is for the government side?
No recordings, the photographs of that.
Who is for the government side?
My lords, I appeal for the respondent state.
Why you are not recording the statement of these persons, complainant and this? Why your officers are not doing this?
Because the investigation has been concluded and the case has been found to be true.
Conclusion of the investigation in the manner in which the officer want to do.
Because the witnesses who have been named in the charge sheet are the informant, my lords, the investigating officer, and my lords, the other witnesses. There are total 7 witnesses named in the charge sheet, including 2 expert witnesses.
So please, who have been, please tell us who are the witnesses said in the FIR and the injured persons. Have you recorded the statement of the injured person? She is stoutly arguing that the
Lordship.
statement of the injured has not yet been recorded. Without recording the statement of the injured, how you can go in a case? Have you recorded the statement of the injured? Please, can you say something on this?
My lords, I'll place on record, my lords, within 3 days the relevant part of the case diary, my lords. Because I'll have to, my lords, see whether he has been examined actually, my lords, and what are the statements which were given by the injured.
Wednesday, come with that document.
Lordship.
Okay. Obliged, my lord.
My lord, I beg to appeal for the petitioner. My lord, he is in jail for the last. He is in jail for more than 2 years and 3 months. In fact, my lord, the main accused is yet to be apprehended, and the trial is at the infancy.
No.
Obliged, my lord.
Okay. May it please, Milos. This matter, Milos, all the accused, Milos, other than the Milos, main assailants have been granted bail. It is admitted case, Milos, that at the time of the occurrence, Milos, I was in custody in connection with of a different case, Milos, 1 month prior, Milos, to the date of the occurrence. Milos, the only thing which Milos has weighed against me is Milos antecedent. Milos, in that case, Milos, I have already demonstrated, Milos, by Milos, the chart. I have been acquitted in 9 cases. There are Milos 6 which are pending against me. Milos, if I can point out, Milos, that Milos, I am nothing to do. Milos, also, Milos, assuming that Milos, I have some cogent Milos, evidence to connect myself, Milos, to the N cases which have been registered against me. There is this N plus 1th case, Milos, which is registered against me. In that, there is no evidence at all, Milos.
Admit one thing. My lord, as an officer,
Not granting anything. Giving
my
you
lord,
opportunity, file counter affidavit.
my lords, I will file the counter affidavit. I just request my lords to see the affidavit in this SLP, which is not properly even executed and so on by my lords.
I accept notice on behalf of the insolvent.
दोनों का notice accept कर लेना, उनमें file counter affidavit within a period of 3 weeks, rejoinder within a week, 4 weeks बाद लगा देना.
Wait for the
Informant को join कर दीजिए.
Milos, I'll
Complainant
file
भी join लीजिए part.
Please.
Please, my lords. Here, my lords, there's a question of title.
There's an earlier will which is superseded by a later will in my favor. Matter comes up before a tenancy court. I am directed to be evicted. The first appellate court says, look, under the statute, this petition should have been returned back because there are civil proceedings pending on the nature of the title. And it is on that basis that the eviction is set aside. Then the High Court in revision says that a revision court could not have gone into the facts. The facts had to be gone into only on the question of there is a title suit pending, go there.
Court impugned order was passed on 12th February. In the month of March, 5th March, he has already vacated the premises.
No.
Yes, Lord, as per the instruction of my client.
Put it on affidavit, then why am I here?
He has already vacated the premises on 13th of March. I filed the execution proceeding. Below the 13th of March, 18th of March, Lord. 18th March 26. 26. Execution proceeding is pending. Today is the date, my Lord.
My lock is there.
For the arrears on behalf of the respondent submits that in execution, during pendency of the execution, the petitioner tenant has delivered the petition on 18th March. List of 11 documents on affidavit be filed within 2 weeks. Full stop. List thereafter.
Great.
Great. The judgment of reversal, my lords. The first paragraph of the impugned order wrongly records that the writ petition is dismissed. It's actually allowed. Notice it's a post, my lords, of professor in industrial engineering. Just turn to page 21, para 24. The High Court says that a degree in the concerned subject is not necessary. The government says to the contrary, the Public Service Commission says to the contrary, the rule says to the contrary. Just turn to page 21, para 24, minutes.
Notice.
I'm praying for an interim stay because there's only one person direction to appoint an ineligible person, minutes. And I was appointed pursuant to...
The appointment, if any made, shall be subject to...
Because I was appointed, I was removed, now he's being appointed absolutely ineligible. Lordship may status quo. I will also not work, he'll also not work, minutes.
So you are happy by that?
Look, I am a graduate in that subject, lords, and a successful person, lords, from the single judge. There are previous rounds where I've succeeded. Look, just look at the perversity at page 21, para 24 minutes.
Issue noted. In the meantime, appointment, if any, shall be subject to final out.
Lordship may say, lord, status quo, lords. Look, there is no appointment yet, my lords.
You know what can be done. Nilesh Goyal Saab, you know what can be done.
Look, I'm only pointing out that there is actually no appointment, my lords. The government, the Public Service Commission, my lords, have both filed affidavits in my favor, my lords. I succeeded before the single judge with the direction to be appointed. No, would your lordship fix a date, my lord? I'll serve them dusty, my lords, at least.
In addition, dusty permitted. Date laga.
Lordship.
My lords, whether I'm audible, your lordships.
Yes, please.
Petitioner in the instant case, but impugned judgment, the has been granted anticipatory bail, my lords. These offences under sections 191 to 193, 190 to 196, in the nature of these, your lords. My lords,
Need not.
from the incident.
You say it's a loss of left eye. Loss of
Yes,
left eye.
100% vision has been gone, my lords.
Yes. Then what is the stage of the trial at present?
Charges have been framed.
Investigation completed.
Yes, my lord. Charges have been framed as well. 16 July, it's fixed for evidence, my lord. 16 July evidence. Yes, but not me, my lord. Not in. I didn't cause that injury. It's specific the role which is ascribed. Those persons went into custody. They got bail. Now everyone is roped in this cross FIR, with this FIR and cross FIR. Please see, my lord, the subject FIR. Please see the allegation, my lord, at page 20. All were there, but
Were there, so how this
and
is a,
so we
it's a
all
loss of the eye.
yes, but
Vision of the eye,
one
sir.
injury by the person caused loss, and we have lodged a cross FIR on which on charge sheet is filed in that. It's a case actually not of 320.
Understand the cross FIR.
Yes, my lord.
Have you received any? This Kamta received any injury?
No, I'm not there.
So
I'm
you
not.
are, then what you were?
I'm not there, my
What
lord.
purpose you were there?
The
Supporting?
everyone is.
Hearing.
I wasn't.
Everyone.
My lord,
Go ahead.
my lord, kindly consider it at this stage. My lord, your lordships may consider. Out 7 persons were made and accused. 6 of them were arrested.
Sir, you will 15 may be there, sir. 15 will be
No,
there.
I bow down. I mean, I'm saying, my lord, I'm only submitting for you.
Master of a criminal side, you can understand.
Oh, my lord, I'm.
Therefore, 34, 149 was there.
Kindly, my lords, kindly, today my learned friend is against an order of granting of anticipatory bail when charge sheet is filed. Charges have been framed, my lord. That part was not disclosed to your lordships when the notice was issued. That the charges have also been framed now, my lords. As far as the trial is started, lordships may put to terms. Maybe the High Court order, I bow down, my lords. The High Court order is not very happily worded. I bow down on that, my lords. It's not.
Now you come on the point.
Yes.
Now you have come on
Yes,
the point.
it is not happily worded. I bow down.
Para 6.
Then, all right, my lords. Then protect me.
Kindly see para 6.
Yes, protect me, my lords, for this when it goes.
You see para 6.
I saw.
All bracket.
I saw it.
Complete.
Because I saw it, I was unhappy with them. I knew why your lordships were not annoyed, my lords, but concerned as far as this order was concerned. I bow down, my lords. Lordships may send it back. I don't come in that way, my lord. Only just protect me. He's a government servant. If he's taken into a teacher, if he's taken into custody, my lords, he's 57 years
He's not supposed to teach all these things.
No, my lord, this happened, my lord.
He's supposed to teach something else.
Yes, but he's not, my lords, kindly consider it, my lords. Your lordships may send it back. I'm not saying anything on that. But kindly protect me. I'll apply again to the High Court. Yes, please set. I'm not saying set it aside and not inclined.
Can be anticipatory in this case, Mr. Davi.
Lords, kindly see the allegation in the FIR. I can show, my lords, the allegation.
Sir, you were there.
Yes, but just see.
To cheer up everyone.
No, I'm not even cheering, my lords.
Cross FIR.
In the cross FIR, my lords, three persons were injured on a.
You are not there, sir.
Oh, so therefore, my lords, I'm saying that.
You can understand a person who is injured in the cross FIR may have come for granted anticipatory bail, no explanation of the injuries are there. You can understand something
Yes.
like this.
Yes.
But in your case, how you are, for what purpose you were there, now you are saying, I am not there, sir. I have not done anything. Please don't touch me.
My lords, that's a stage of anticipation. I'm only, my lord, one submission, legal submission. This offence would actually fall under that old 335, my lords, the new 122.
No.
Yes, my lords, it's on a grave and sudden provocation, the same grave and sudden provocation. It's a case of grave.
Don't brought us to that extent, sir.
But kindly see that section, my
Please
lords.
say something you know,
All right,
understand.
please
what
don't
is the
say.
impact of that.
I'm only praying, my lords. I'm only praying.
Yes, sir, please. Sandeep Kumar Sen. What do you want to say? His contention is, this is anticipatory bail granted, it's September 25. You have challenged in the month of January 26. All right, the charge sheet have been filed in the meantime. Everything has been done. Trial is going on. Charges have been framed. Now at this stage, we can understand the injury is grave, but that grave injury is not caused by this man. Grave injury is caused by another person. And that man has surrendered, and after surrender, he has been also granted the bail.
My lords, my humble submission that the offence was committed in furtherance of common intention.
To him.
And all the offenders have similar role to play, my lords, and this person was also involved in the same manner, my lords, and the Honorable High Court has granted bail.
What is grant of the bail? This is
a humble submission that bail has been granted merely on the basis of counter FIR, my lords, but what is that the
you have to do something, Mr. Davi. After hearing learned counsel body, the instant petition has been filed seeking cancellation of the bail with the order dated 4th of September 21st of the respondent number 2, namely so and so, was released on anticipatory bail. After hearing learned counsel for the party, we find that the order is unreasonable First up, in any case at present, the respondent is on bail since last more than 8 months. The charge sheet has been filed in the meantime, and the charges have already been filed. The trial is in progress. Therefore, we are not inclined to entertain the present SFP. However, it is suffice to say that the respondent number 2 shall regularly appear before the trial court and shall not ask for any adjournment during trial. Regularly appear, not ask for adjournment, and shall not intimidate any of the witnesses. Otherwise,
I'm grateful. Grateful.
For conciliation.
Yes, please, my lord. Yes, please, my lord.
Item 3, for the state of UP.
Yes, Your Lordships.
Have you seen this file?
Your Lordships had passed over the matter for the presence of the complainant itself, Your Lordships.
You are for?
For state, Your Lordships. But they are not here. What are the complainants on it?
Yes. What we can do here in this case, sir?
Yes, my lord. From the state.
None appears on behalf of the complainant, though the matter is taken up in the second round. Please stop. There were 6 accused. All accused granted bail. All
Yes, my lord.
granted bail.
Other than me.
Except the petitioner. Full stop. The present case is based on a private complaint. Wherein private complaint and also of circumstantial evidence, wherein the appellant is in petitioner is in custody since more than 2 years and 2 months. Full stop. Considering all the attending circumstances wherein the charges have not yet framed.
Your Lordships only request that they must participate in the trial.
Without expressing any opinion, deem it appropriate to release in bail. Release the petitioner on bail, but conditions for it. Next.
Please, my lord.
Item 4.
May it please,
Item
Your
4.
Lord. Your Lordship has directed the state to verify laws and find out as to why laws.
Who is for the state?
Appealing for the state, my lord, through VC.
Yes, please.
The directed the petitioner to get the treatment through any government hospital, and it was assured by the council appearing for the petitioner that they will be undergone the treatment as required, given by the PGIMER
Yes.
as per the status.
They are saying you are not allowing us in a proper institute, so I will go to private treatment.
Lord, one of the questions that was put forth by this court, Lord, to the council for the respondent was as to why they are charging 2 lakh rupees. Lord, this government hospital was charging Lord, 2 lakh rupees. So,
2 lakhs rupees.
Yes, ma'am. So they were directed to verify Lord, as to why they are charging 2 lakh rupees.
Yes, why you are
That hospital.
Gautam ji, why you are charging? Gautam ji, we are audible to you.
Please, my lords, I'm hearing now, my lord.
Yes, why you are charging, sir, from these persons?
The petition.
Release on bail.
The petitioner wants to undergo surgery in Chandigarh hospital, not in any government hospital, falls within my state, my lord. If that is the situation, I'll assist and take care of the proper treatment. This hospital doesn't fall in in the state of Himachal Pradesh, my lord.
Treatment.
Yes, Lord.
When you have to undergo the operation?
This is imminent, Lord, any time.
It's imminent, we grant for 3 months, go for operation, then come back.
I'll do that.
We'll keep for 3 months adjourned, till then we'll
I'll do that.
keep it pending.
I'll do that. I'm grateful, Lord. Deeply obliged.
The petitioner is permitted to undergo the surgery. The choice of your hospital in the meantime, the interim protection granted shall remain continue, at least in the month of September में लगा.
I'm grateful, Lord. Deeply obliged. Deeply obliged.
List of the paper of the operation, the paper, 11 papers regarding performing the operation be filed.
We are in
Full stop.
Deeply obliged. Deeply. State council is here.
Lords, I have spoken to the persons concerned. My lords may place it on Friday. They'll pass orders on the representation. They're just verifying the awards. So my lords may place it on Friday. They'll pass the order on the representation that has been made.
The learned counsel appearing on behalf of the respondent submits that in furtherance to the directions issued by the High Court, the appropriate orders will be passed on or before Friday.
Yes,
coming Friday.
my lords may place it on Friday. I'll bring on record whatever.
Further orders on Friday.
Friday, man.
Friday we did
It-
Yeah, please, madam. Well, here considering that there was clear-cut case of violation of principle of natural justice, Your Lordship, High Court has in the writ petitions granted the status quo order. That order was challenged before the writ appeal court. Writ appeal court, in spite of hearing, Your Lordship, dismisses vacates that order, and Lordship may kindly appreciate the hearing was so-called given on 15th December, whereas my earlier representation, which was of 28th November, was so-called rejected on 4th December itself, and oral hearing is given to me on 15th December. Well, that's absolutely a sort of a communication only to acknowledge us the personal hearing and to inform us that your application has already been rejected. Otherwise, the Lordship considers on merits, my bank guarantee is already there before him.
This case, sir.
Most kindly appreciate. My bank guarantee is already there before him.
Say whatever it is, sir, what is the matter of a contract?
Agreed, my lord.
Protection was granted to you.
Yes, my lord.
Then after granting the interim, it was challenged. This order has been passed. In the
My lord, I'm there. I'm still there in the possession, Lordship. Because my itself was considered 25. I'm still there in possession, Lordship.
Position after grant to the contract to another LOI has already been issued.
That itself LOI is wrongly granted, Lordship, because my consideration is not there, Lordship. Lordship, kindly appreciate the twofold consideration which is there, Lordship. My bank guarantee, the FD is not being considered, the wrongly marks is given. Secondly, as regard to my age.
Mister, we are not inclined to entertain the SLP. However, it is suffice to say that the writ court may take recourse to decide the pending writ petition of the earliest. And the aforesaid request to the court, High Court, the pending petition still disposed. Present SLP still disposed.
Malas, may I request on one thing? Since the status quo was there, I was already continuing, Lordship. Let the status quo be continued. That is all I'm requesting, Lordship. And direct the High Court to decide within 6 months, Lord, not an issue, my Lordship. Lordship, pleadings are complete. I'm told the pleadings are complete. I was already continuing in the premises, Lordship. And I was continuing already the retail outlet, Lordships. And state, by virtue of our High Court order, status quo was there, Lordship. Lordship, I'm only requesting Lordship to continue that status quo because the writ appeal, without going into the factual aspects of it, without considering this aspect, has merely not considered these aspects at all, Lordship.
Thank you.
Lordship, once more, I beseech your Lordships only to make for time bound, your Lordship.
Yeah, heard you, sir.
Please, my Lord. Please, man. Please, my Lord.
My lords, larger issues, your lordships may consider it after vacation, but I think my colleague wanted to press for bail, my lords, in point 2. My lords,
Question is not necessarily you were appearing on the last date as Solicitor General was saying.
yes, my lords, the learned SG is leading.
This issue.
Yes, my lords, he is still, my lords, trying to resolve it.
Lord, 4 patients.
But the issue is coming. Suppose we release on bail.
Yes, my
Where
lords.
this man will go.
My lords, in the detention center, my lords.
All right. Then detention center cannot be for an inordinate period.
Yes, my lords.
Otherwise, there is no purpose of grant of the bail. This is the basic point here in this
Yes,
case.
my lords. Your lordships
We
will,
have to consider this. What can be a recourse of this?
so my lords, that,
Grant of the bail is something.
I bow down, my lords.
Putting for a limited period until you take a recourse on behalf of your office or central government. This
Yes.
is another.
Yes,
way.
my lords. My lords, the
And
learned,
cannot decide
learned
now.
SG is trying to resolve those
Decide
issues.
because don't have time that much. Though
Yes.
I can hear and can pass an order later also, but I am
Yes.
not interested in this.
Please, my lords. My lords, in point 2,
We are
the
doing-
bail.
They are trying to
Yes, my lords.
finish by 29th of May.
Please.
I'm not interested in this now. In particular, my thought process is different in working. Anyway, you can go in after vacation.
Please, my lords.
My lord,
That will be, sir. Even after you will come out on bail, where you will go? That was the basic problem in this case.
Yeah.
Justice Oak said something, but not considering that basic provisions. Why we are asked Mr. Sam Diwan for this reason? We are aware where the point was being lying here in this case.
Lord, the note shared by the learned amicus
But
addresses
please,
all the.
Nothing can, we can understand, sir, but this is a point everywhere. Even we pass an order of release. You cannot be released. And where that was a case of the Karnataka, there was some provision. Officers not doing, they are saying state has to do. It is not like this. We have seen that provisions on that at that time when I was examining this. I am aware of this, everything.
Essentially, since there's a new act, they have to revise their manual now.
Yes.
Once that internal process takes place, 70% of the problem may get over and we'll have some
That
guidance.
is basic problem,
Yeah.
Divanji.
But they'll
this
have
is
to
I
do
was
it
doing
quickly.
this.
They'll have to do it quickly.
Beginning, I visualizing this
Yes,
situation.
and that will
even
provide
then,
guidance for all their
I
officers.
say much more.
Yes.
That judgment is not correct, everything.
Yeah, it
That is
doesn't. It
considered
still leaves a
ethics.
gap. It leaves a gap.
So many gaps are there in that also.
Well, it's the learned SG is going to, my lords, is looking into and trying to find a solution.
We are fixing in, madam, in
I'm
the
great.
first week of the August.
I'm great.
Whatever you want to do it,
Lordship.
otherwise it may be hard.
Lordship.
Yes,
But
very
I am fine. That is all.
Please.
Again. Since 2-3 occasions on the assurance of learned SG, time was granted. However, still the discussions and to find out a way out is in process. By way of last indulgence, we say that needful be done by the SG, SG oblique ASG within 8 weeks. Otherwise, the case may be heard on its own merit list in the first week of August.
Grateful, my lords.
That's in 46. I'm appearing for petition number 2.
I must tell your lordship before the merits, there appears to be, the advocate record was for both the petitioners. Yes, now some advocate has filed saying that petition number 2 had not signed the wakalat, is only for petition number 1. Now, all these, I've
Lords,
got
I'm
the
appearing for
advocate
petition
record
number
is
2
here.
here.
Just 1 second, the advocate record is here. The local lawyer from Jammu and Kashmir has filed an affidavit saying both of them came to my house. That's what I'm saying. So which is why I'm saying, please.
You people may decide.
That is what. So if he wants to engage another lawyer, no problem. Let him have another lawyer. But I don't know what he wants
My
to
issue
do
is different. I have
he's
never
got a-
come to the
Just
Supreme
1
Court.
second, Mr. Andrabi. Just
Please,
give me
please,
1
my lords.
second.
Please.
Now, Lordship has granted a state.
Sir,
Lordship.
Mr. Andarbi, wait, please wait.
Yes. In this matter, against the High Court order, we came and Lordship has granted us a status quo order. Now that is continuing. Now, this matter is listed today to refresh your Lordship memory because my learned friend came and mentioned this issue. So I was telling them, subject to what your Lordship
Yes,
feels.
what do you want to say, Mr. Munir?
Yes.
Yes, my lords. The petition number 2 is also on the VC. My submission is that I have never approached this honorable court to file an SLP. My signatures has been forged by petition number 1 along with some local councils.
So you do not want to press this SLP on behalf of petitioner number 2. You want to say this?
Let him withdraw.
No, my issue is different. That how come they can put signature on my behalf?
Learned counsel, what do you want to say?
Come to my knowledge that they have been doing the same before the trial court, before the high court. I have never approached it before any forum.
I'm not interested,
Yes.
sir. Go and file the complaint against your advocate. Who did this?
I have filed the complaint before the Vigilance High Court.
So we treat this SLP not pressed on behalf of number 2, petitioner number 2.
Yes, Lordship may do that.
Fine. And
Unless
you
this
are
is the
permitted
deliberate
to take
effort by
recourse.
petition number 1. He is a property dealer.
And you are permitted to take recourse as permissible. Have you heard our voice, sir?
Yes, Maharaj, I am hearing.
We, on behalf of petitioner number 2, we are not entertaining this SLP. And the petitioner number 2, if having any grievance that his wakalatnama has wrongly been filed, he is at liberty to take recourse as permissible under the law against that.
Yes,
Maharaj, I request an investigation may be initiated in the issue. Because this is not only before the Supreme Court, this is before the trial court as well as the High Court.
As much as you have, sir. We don't have that much time, sir.
I have lots to say. I'm keeping quiet on this issue. I have lots to say on this issue, but I don't want to bother your lordship. That's why. That's what I'm saying.
To be decided, sir.
Absolutely, my lord. Because
you decide, clients may go and fight.
absolutely.
Observation may be made regarding the same that
Applicant records can't function after notarized affidavit. One client comes and says this. It's impossible.
Maharaj, there is no. I have never. There is no notary. There is no record on the notary register.
Adil Munir अंदर भी. Adil Munir अंदर भी.
Yes, my lord.
Yes. On behalf of petitioner number 2 and submits that he has not signed wakalatnama. And submit that she has not signed wakalatnama.
As well as the affidavit.
It's wrongly been filed. However, the action may be initiated against the persons who have taken the recourse for filing of this SLP. Full stop. At present, on our part, on his say, on the saying of the Mr. Munir, this SLP, and we are not entertaining this SLP on behalf of petitioner number 2.
Yes.
Full stop. It is open to her to take recourse against advocate, if any, required under the law for filing the case without her due permission. Full stop. With the aforesaid, this can be treated as not entertainable on behalf of petitioner number 2, and it be pressed upon only by petition number 1.
Yes.
Full stop. The amended memo be filed in this regard. Full stop. List after vacation.
Milords, I appear on behalf of respondent 1 and 2. I'll file counter affidavit to that respect. Milords, we don't have instruction from that.
There are 3 to 11.
Yes, Milords, I know. They are in contact, but
may not be.
they are in contact, but they have not yet approached. We'll speak to them. We'll file counter on behalf of 1 and 2, Milords.
May I just say,
Affidavit has been filed on behalf of respondent number 1 and 2.
may I just once, Lordship had said advocate. Actually, his allegation is the petition number 1. Lordship may say Lordship has not expressed any opinion.
Petitioner allowing the local advocates, not the advocate on record. It's the local advocates, not the advocate on record.
Lordship may say Lordship has not expressed. Let the advocates, the clients may have their own problems. Let's not pour advocates.
Local counsel, Maharaj, not the advocate on record.
Any opinion on the allegations?
Obliged. I had filed a detail after I told them we won't bother your lordship, but that is absolutely unfortunate. No advocate on record can function like this. Notarized affidavit, after that clients have a fight and they come and blame the advocate on record.
We are
It's
not
really
interested
unfair.
in this. And this
Obliged.
is not a forum also.
Yes,
Grateful, Milords.
Yes, ma'am, sir.
May I please?
I filed my supplementary counter affidavit as well.
Yes,
and
yes, please.
the petitioner has
I
submitted
also
his
filed the
matter.
rejoinder affidavit. Lord, the
Yes, sir.
yes, please. Lord, there was 46 posts were vacant in the irrigation department. Lord, the applications were invited in 2015. Lord, the petitioner and respondent number 4, Lord, they filed their applications against the physical handicap post. Lord, the result was declared
The simple question in
Yes,
this case is that some answer of the questions which was valued in favor of respondent number 4, at that time merit of the petitioner was 72.75 and the another merit 72.50. On revision, it was found from the next that this is a right answer. The marks, if given, then she will be on higher.
No, this is not.
That is the point. That she would come on a merit.
No.
72.
This is not the case. This is not the case. The case is not the against the 100 questions, my lord. Some objections was raised against the answer key, and my lord, the 10 questions were found sent to the expert committee. The expert committee, my lord, submitted the report that just these 10 questions answered are being changed. And on the recommendation of the expert committee, answer to the 10 questions were changed. My lord, and thereafter result was declared. The petitioner hearing was declared successful. Note the respondent number 4 challenged the selection of the petitioner by filing the writ petition that is the question number 100, the wrong answer has been mentioned in the revised key. Lord, it was the result of 46 candidates. Now, my lord, the learned single judge dismissed the petition. Lord, you may kindly have the page 41.
Learned single judge dismissed it, division bench allowed, saying that this answer is correct, whatever she is saying.
My lord,
so then accordingly the valuation will be done.
My lord, the High Court division bench, my lord, has directed that marks be awarded to the petitioner alone. My lord, when my lord, what has been held by this court?
It will be awarded to everyone, no?
My lord, then the entire result is to be reappreciated.
Let it be done. What's wrong in this?
So, my lord, only in regard to the petitioner, it has been reevaluated. Not in regard to the 46. Lord, the 3 judges bench in which
you are concerned of yourself, sir. You are a private person.
Lord, I am concerned.
Authority or the
Lord, I am concerned. Lord, I am
examination body.
Lord, I am concerned with myself.
Your concern is if you are let it be revision as directed by the division bench.
No, there is no direction. Lord,
we cannot shut our eyes when the answer is correct.
My lord, no, my lord, it is not. Lordship may kindly see the answer suggested by the commission itself. Lordship may counter affidavit, page 17, my lord.
So please, whatever the answer is, question number 100. What is the answer?
Answer is Satal, C, not the D.
Yes. What answer given by the respondent number 4?
D.
My lord, the correct answer is, my lord, the Bhimtal. No. I have clarified in my supplementary affidavit, my lord.
No. You are the body.
No, my lord. I am for respondent number 4. My learned friend is saying Satal is correct answer. Correct answer was Bhimtal, my lord. And the Chain Ayog in the next examination, my lord, removed the wrong answer. I just also annexed the answer sheet, my lord, also in my supplementary affidavit.
We have seen.
Lordship may kindly see the.
So they have corrected themselves in the next examination.
Lord, the counter affidavit of the commission, Lord, they say that it is Satal.
But this cannot be done.
But Lord, the High Court can, Lord,
is it right that in the next examination same question came and then they said
Lord, not exactly the same. The language is something same, though it is in regard to the
intent of the question is same and answer is the same. Then how it can be?
But Lord, the subsequent question cannot be this. Lordship may kindly see one thing. Judgment of this honorable court. Lord Vikesh Kumar, 3 judges judgment, which says that if the answer is corrected, then it should be corrected in respect to all the candidates, not in regard to the one candidate.
No one has come before us. Why we have to
no one. That's why
are you a PWD candidate or are you a different candidate? Please, are you a PWD or different?
Pardon
are you a different or PWD candidate?
I am the PWD.
So why you are asking for any other? In comparison to PWD, if it is question has been decided, why we have to interfere?
My lord, I am the Lord, just.
And Lord, what is respect, my lord? She has not attempted that question also. My
lord.
No. Making my explanation.
Just wait, sir. Primarily, he is struggling. Huh? We want to more struggle with them. Wait.
My lord, Lordship may just.
Yes, sir.
Vikesh Gupta.
Just What do you want to say?
Lord, my submission is,
Mr. Lokpal Singh, anything else?
Lord, my submission is that this honorable court has categorically held in three judgments.
One and answer. This is a substantial justice problem in our court.
My Lord,
Please
substance.
listen for a minute.
Yes, my Lord.
The intent of the question which is of this time and the subsequent time in the same process, this same commission, it is the same question was there. The answer in this time said Sattal, answer in the next time said Bhimtal. So all right. So they are saying no, Bhimtal is the right answer by this time also. You are saying no, this time it not be, next time it may be.
My submission, my Lord, my submission, Lordship is kindly three judgment.
You will not go through. Anything else?
My Lord, Lord,
Nothing can be done.
Lord, after, my Lord,
Nothing can be after.
my Lord, my friend is placing reliance on the Rajesh Kumar judgment.
Asked by the High Court. SLP has been filed. After hearing this, no given in conference. Thank you.
Lordship, so please to issue notice and stay the proceedings on the last date.
Mullets were not told, Mullets, two important facts by the petitioners in the SLP. One, Mullets, that Mullets in this JV between the petitioners and the... Mullets, the only thing is, Mullets, then can I... No problem, Mullets. No difficulty. But the only thing is that perhaps my lords were not told. No problem, let it be heard. Because I'm only saying this limited submission that perhaps my lords were not told that I have a counterclaim which is going on before the arbitrator and I have completed my oral evidence in my counterclaim. Well, the stay passed on the last date, Mulad is staying the proceedings in my counterclaim. Because he will proceed with his claim if the court agrees with him. But my counterclaim should not be stayed, Mulad. I have completed.
Let it be simultaneously proceeded.
That is precisely the submission.
Can I just say, Mulad, the impugned order is 20th January 2026. For 2 months, Mulad, they waited. Those 2 months, Mulad, they proceeded with my counterclaim after the impugned order. Why should it be stopped now, Mulad?
Now nothing can be done.
Well, the dates are 17th and 22nd of June, Mulad.
Date fix कर दीजिए इसमें कोई तो on any NMD का date लगा दीजिए. The mean till next date the interim order to continue.
Most great.
Mulad, counter, we'll file a counter, Mulad.
Counter affidavit has been filed. Do you want to file?
They have not filed a counter. They filed additional documents. They want to file a counter.
You want to file counter?
Yes.
Additional document along with you file it. This
We filed the additional document, which they did not put in the SLP, Mulad. The application, Mulad, which we filed, which was allowed by the Mulad, the application which
like this a paper book of more than 500 pages.
Mulad, the application which impugned order was passed was not filed.
Counter affidavit we filed within 4 weeks, 2 weeks for rejoinder. Miss thereafter for MD lagana. Till then, till next date, interim order to continue.
Mulad, could there be a date in July, Mulad, because the arbitration is stayed?
Sir, July 2 weeks. Let us first week miscellaneous. Next week you can understand.
Mulad, first week of August.
First week of August.
I'm so obliged.
First or second देख लेना कहाँ.
Yes. Grateful, Mulad.
May it please, Your Lordship. No, this is coming up for my prayer for bail, Milord. Out of 11 years, I've already undergone 8.5 years. 8 years, 6 months I've already
You
undergone.
can do, sir. I've seen the case on merit. Nothing is on merit, sir.
No, Milord, may I just tell Your Lordship? Milord, I have
Nothing
examined.
is on merit, sir.
No, merit.
On merit.
Milord, 3 defense witnesses we've examined, Milord, who have categorically said that I was picked up from my house.
Yes, madam.
Was picked up from my house, and was then a false case was framed on me. Was there police witnesses?
Your Lordship's 1.2 kilos of charas has been recovered.
Out of
Independent witness testimonies also exist, Your Lordships.
No, 9 years I've undergone. I'll meet my fate when it is heard.
Your Lordship's concurrent orders of conviction. Concurrent orders of conviction.
After vacation.
Firm, I'm grateful.
Yes, sir.
Please, Lordship, the petitioner is seeking questioning of the FIR. The complainant is appearing online.
So in the previous occasion, my lord, they directed the complainant to be joined. VC, my lords.
Yes, yes. What is her name?
Jyoti. Video not बिल्कुल.
Where she is connected. I think some. We'll take it in Passover.
Which ones?
Convey them. Passover. Because she said,
She said.
yeah, which is Vidik Sahayata Kendra.
Bagicha.
Bagicha in
Chhattisgarh.
Chhattisgarh. Any secretary is there. Bagicha is there. बागीचा की सेक्रेटरी है. विदिक सहायता की सेक्रेटरी है वहां पर. कोई सेक्रेटरी प्लीज. कौन है वहां पर सेक्रेटरी? आप हिंदी समझते हैं ना? Let them set it. Next thing.
Passing it over.
Convey them.
Hello, it's in item 51. Mr. Supranshu Padi, AOR, is connecting through online.
जी.
Lordship, the compliance has been completely done, Your Lordship. The balance amount of 15,50,000 already transferred in the account of the petitioner, Your Lordship, on Friday or Saturday.
Yes, my lords. We have received yesterday. But
yes, my
however,
lords, that's correct, my lords.
The proof of the deposit is also given, Your Lordship. The calculation has been done on the basis which the petitioner had themselves mentioned in their reply, Your Lordship, and on the basis of that, basic DA completely given, Your Lordship. So the complete satisfaction of Your Lordship direction has been done, Your Lordship.
Wait. Padi,
Lordship.
Mr. Padi.
Please, my lords. My lords, I've spoken to the client personally, my lords. He has said, my lords, he's happy. He's satisfied with the compliance, my lords. It is in terms of my lord's order. He has received 22 lakhs in all, my lords.
All right, fine. Okay. In pursuance to the order stated 18/5/26 and 25/26, the compliance has now been reported and the amount has been transmitted in the account of the petitioner. Please stop this to you with complete satisfaction. The present proceedings is dispersed.
Lords, he's also asked me to convey, my lords, his gratitude. My lords, he's been fighting for this matter for so long.
Our gratitude.
Right, lords.
Yes. Thank you.
Lordship.
Yes.
I am for the respondent number 2 insurance company. Humble request to refer this matter
Petitioner was
to Lok Adalat.
21 years old. He was met in an accident and he was in a vegetable condition because he was according to disability certificate is 84%.
Refer to the Lok Adalat. Instructed by the council. Basically, there is a letter.
53, my lord, needs to be fixed for final disposal. It would need time, my lords.
This is a letter.
Counter has already been filed, my lord. For counter, they had circulated.
There is a letter, sir.
Please, sir. Yes.
In this case, I have not seen because there was a letter.
That doesn't matter. Please,
There
sir.
was a letter, so I have not seen,
But
sir.
they filed the counter today, man. For that,
They may have filed counter.
day after tomorrow, it may be taken.
Why it should be taken, Mr. Jain?
My lord,
Day after.
2001, we are suffering, my lord.
Nothing.
No, in spite of the
Sir,
dismissal of,
I played my inning now. Khatam, finished.
my lord, despite of dismissal of the SLP, my lord, they are not paying me, my lord. That
Counter affidavit has been, though there is a letter, but it is stated that the counter affidavit has been filed. Rejoinder, if any, be filed within 2 weeks. List after this partial.
some date.
Yes.
Please.
54.
The state, the university has filed compliance. The state has taken exceptions only to one fact. If your lordship just have a state affidavit, I'm in 54.
Case by case. Yes.
My lord, if I can give an overview of all 6 cases, there are 6 contempt petitions because primarily it is my response now. Lord, so far as 54.4 and 54.5, the last 2 cases, the university has passed orders on 15th of May and 18th of May, supplied to me on 25th of May, 23rd of May. So I need to process it, my lord. I need to file my response because orders passed last week. So far as, my lord, 54.3 is concerned, university has not passed any order. So university has to first pass an order, then put it to me. Now, my lord, so far as Meera Singh is concerned, 54.1. University recommended for giving the benefit, we have accepted it. So this can be disposed of.
But I appeared in Meera Singh and I appeared in 54.5 also. So for Meera Singh is concerned, my lord, university has made a recommendation that state should pay the amount. Now the state has filed a reply saying this, that let the university pay. Now, my lord, who is going to pay? That is
My lord, for that, let a statement be recorded. University, of course, university has to pay, and I have to reimburse the money to the university. University. All right, Lord, we will release the funds, Lord. We will do that because we have accepted the recommendation. Insofar as Meera Singh is concerned, 54.1.
4.1. In this case, the recommendation of the university has been accepted. However, accepted by the state. The Superintendent Council for the state submits that in case the university do not have the fund, we will pay the amount within a period of 1 month.
Lord may say 2 months, my lord.
Why 2 months?
It takes, my lord, process.
Granted, sir.
As your lord.
It's a period of 1 month, as directed in the main order.
Now, my lord, where we are opposing, my lord, item 154. In 54, my lord, we have accepted recommendation with regard to petitioner number 3, 5, and 8.
No,
And
we are only one petitioner. It is only
No,
one
no.
petitioner over here.
In 54,
Yes.
item 54, in the contempt petition, there are 10 petitioners.
No, in this present contempt, only one petitioner is there, sir.
One only.
Only one.
And you accepted for that.
My lord, this Shyam Kumar, my lord, what I have said is, my lord, I have accepted, but my lord, rest we are opposing. Now, my lord, in fact, my lord directed me to furnish the basis.
What is this? You come to the amended memo of parties.
That is where the estate was also made party.
Oh no. In this amended memo of page number 2, number of persons are party.
No, that was in original contempt which your lordship disposed of in 2025. It talks about that memo. In the present contempt petition, which now it is filed in 25.
Dr. Shyam Narayan Singh.
Only one person is there, but they have filed in response to in respect to all 10 persons. I don't have any problem, any issue in that respect.
We have not granted.
Let us understand. So now this contempt is only on behalf of Dr. Shyam Narayan.
At present, only Shyam.
So Shyam Narayan Singh, university passed the order.
Yes.
The state has agreed for.
No, my lord.
State
Shyam Narayan, we have not.
Only one.
And now, my lord, in fact, wherever we have not agreed, because while passing the main order, this honorable court said, university will.
We are aware, sir. You are taking a different advantage. I am not.
No, 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 I'm not. My lord, in fact.
Something more.
Correct. My lord, in fact.
Trying to say now you whatever you want to do, go and interpret. Let it be interpreted in any manner. We are not interested in that now.
Lord,
we did our job.
That's right.
Go ahead.
Yes, in fact, my lord,
Whatever
granted us the. My lord,
in your way.
My lords, granted us the liberty to challenge the recommendation wherever we are not accepting it. But wide order dated 23rd of March, my lord, put it to me that what is your basis of not accepting the recommendation? You must prima facie satisfy us and then we permit you to challenge it. And we have already processed it to challenge the orders of the university. My lord, wherever there is a attendance register of a teacher for the relevant period, and the relevant period in all these cases is between 2014 and 16.
This is not permitted to you. This is an inquiry to be done by the university, sir.
My lord,
Not
in
permitted
fact,
to you to do this
that is
inquiry.
why, my lord, that is why, because I am supposed to pay the money.
Please, you were supposed to say and represent. Have you taken this stand before the university?
My lord, they never heard me. That is one of my grievance. University never heard me.
Where is that order of the university? Tell us. that-
Yes, my lord, the orders of the university are placed on record, my lord. They never heard us, my lord. They said there is an affidavit of the employee that he has worked. There is a common affidavit of the principal that they continued. There is no attendance register for the relevant period, and hence we recommend it. Wherever there is a attendance register, we have accepted straight away. But where there is absolutely no documentary evidence,
think they want to challenge that order of
Only two aspects. Only two aspects. Your Lordship just have their response, which they filed on 23/4. The state response. I'm only referring to that. I'm not going to that present university. Now, Your Lordship just have para 9 of that. They say about Syamnaran, the present petitioner, that from 2014 to 16, attendance register is missing. Attendance is not there. Now, in their same affidavit, they say, I'll just read out, that all these employees and non-teaching staff of those college and by Magad University was stopped from working. That is their acceptance. They have accepted it. And that order by Magad University was passed in June 2014.
You can ask for the cost at that time. What we can say?
No, I'm only
if their
saying.
stand is not correct.
I'm
you
only
can ask the cost against him.
No,
the court may pass an order of cost against them.
I have two suggestions
and
to
we
make.
will give the amount along with the interest. We can say this.
No, I have two
Amount
suggestions.
already stand paid, we have to recover it.
No, I have only two suggestions.
That's right, that's right.
Once the state accept that order was passed by university and subsequently a state by Honorable Supreme Court, and ultimately they were allowed to work. During that period, they worked somehow or the other.
You adjudicate all these things are here in contempt.
Then, Your Lordship, may I suggest one alternative? Now there is an amount determined by university. Amount is around about 80 lakhs or so, or whatever it respect to all other.
Another aspect is,
yes.
Put it in after vacation.
No, I'm only suggesting one alternative. Only one alternative, Lordships. In the meantime, can this
after vacation you can argue both?
I'm only suggesting. I'm only suggesting a via media. I'm only suggesting a via media. Lordships can take a call on it. That let that 2-year period from 14 to 16 be withheld. The amount for that is as per the state objection. Rest amount may be released because their objection is only respect to that, and let pension be started.
Objection is of that period, no?
Lord, we
That is
have
their
rejected. Lord,
Your objection is of that period.
Lord, in fact, what we say is.
Your objection is of that period, no, sir?
Lord, we say there is no attendance register for that period. We say 14 to 16.
There is no period.
Lord, we will take instructions on that. Lord, that offer he is making here for the first time. We will take instruction.
This is not something here in the court proceedings. Sir.
It is here in the court proceeding. He has never said that you don't consider my service for those 2 years and then remaining. So, Lord, we will take instructions on that.
Pay verification cell has also examined the attendance, but whatever it may be, pay verification cell has also examined.
In this, on filing the counter affidavit, the state government said for certain period, the attendance register is not available, has not been produced. Therefore, for this same period, they are not agreeing the amount to be paid. However, to which in terms of the liberty granted in the main order dated so and so, is asked that the content may be disposed of with liberty to the state to file a petition for the High Court. After hearing the counsel for the parties, we are of the view that with respect to the disputed period, the amount may be withheld and the recourse before the High Court may be taken. But for the remaining period, in terms of the order passed by the university, the amount be paid to the petitioner. Needs to be done within a month and within 6 weeks, and compliance be reported.
Your Lordship may indicate the period 14 to 16 because that is their affidavit. No, that is their affidavit.
14 may kindly may not put it. We will file an affidavit, Lord, with regard to that.
Month of that.
Month they have not given. Probably it starts from June 2014 to 2016 November October.
They have said.
Not they have not said the month, but they have that para 9. Para 9 of affidavit dated 23/4/2020.
Dated 23/4/26.
And the pension may be started. Only one more request. Only one more. Pay verification they have to give state because ultimately
said pay nothing more. Let it come.
Because it will come. What happens, Your Lordship, may kindly appreciate. 25% deductions is made in the pension if the pay is not verified by the state, by the cell.
4.2.
54.2 is the same. Same order can follow. Your Lordship.
This is of which period?
Lord, the same period, 2014-16.
Which para?
The same para.
9.
Same para.
Same order. 54.1 and 54.2. 54.3.
Yes, madam.
54.3.
Yes, madam. I appear for petitioner.
Pass an order in this.
No, my lord, notice was issued, they accept.
University passed an
No,
order.
no, my lord, state passed the order, my lord. The state has filed a counter affidavit saying this, that university has not decided anything. So and university was present on that date. No,
He has not filed his claim.
no, my lord.
28th February 2025, the deadline, he wrote a letter saying, I will furnish a detail by 4th of March 2025. He has not submitted claim and not orders.
Lord, your lordship, in another matter, what my lord friend is submitting.
Have you submitted the claim or not?
Yes, my lord, we have submitted the claim, my lord.
What is the date of submission of your claim? Can
Date-
you show us?
No, my lord, date of submission.
Can you show us, sir? In place of fighting, please show us a document, sir. We will refer it.
My lord,
Finish it.
Yes, my lord, it was slightly delayed.
Have you submitted a claim, sir?
Lord, I have submitted the claim.
Or you file a rejoinder of this along with that claim?
Very well, Lord, I'll find the rejoinder.
54.3 में rejoinder करें.
Let
You have not filed any counter.
देखिए 54.3 में लिखना. Council for this university has orally submitted that the petitioner has not submitted the claim for adjudication. Please stop. However, petitioner prays for and granted 2 weeks time to file the additional document along
Yes.
with the claim.
Along with the
Submitted to
claim,
the
my lord.
university.
Yes.
Full stop. On filing such additional affidavit, the university and the state shall file their respective counter affidavits. 54.4 में
My lord, they have passed.
the
university has passed an order. They have complied. Now the state has to take a call on that.
Last week, the orders are passed.
4.4 and 54.5.
Yes.
University has passed the order. However, the state has to
Please. Examine and file our.
file the counter affidavit.
Please.
In my 54.5, my lord, on behalf of the university, in 54.4. But that compliance affidavit is not complete, my lords. In other cases, they have quantified the amount and mentioned in the reasoned order. In my case, they have not done it. Again, I will have to run to pillar to post, my lords.
In piecemeal, we can't say so, sir. Let them say compliance is not there. Finish it. Next.
The large number of other cases also university have decided if your lordship.
They say so, sir. Only 5 cases, 6 cases.
I understand limitations of your lordship. I understand limitations.
Great.
Find our compliance affidavit.
Could your lordship to give some
Terms
date, my
of
lord?
my lords.
It will come in August. Yes.
If your lordship will see our compliance affidavit, para 6, my lords.
We've not received this compliance affidavit, Milos, and we've not received any money also, Milos.
We have not received
Any money, Milos, and we've not received this compliance affidavit. Either of the two things we've not received.
Signed version. I'm handing the copy of
the
compliance affidavit.
Milos, notional benefits were granted to me,
Now,
Milos,
my
and
lord,
that-
actual, which has been decided for actual benefit, my lords. In terms of my lord's order, my lords.
Where is that
My lords.
compliance affidavit?
My lords.
Dated 25/5.
We have filed it on 22nd, my lords.
22nd.
22nd May. खोलो ना, तो खोलो, कहाँ है? ये है. Kindly come to paragraph 6, my lords.
6.
Not 6. Well, para 6, my lord. May I place it, my lord?
Yes.
In compliance with the order, aforesaid order dated 8/5/26, the respondents have decided to comply the order of this honorable court in its letter and spirit, and hence it has been decided to grant actual financial benefits to the petitioner, Dr. S. N. Sarma, in the peculiar facts of this case, and have issued office order number 18/4/26, dated so and so. That order is, my lord, annexure 1. Kindly see, my lord. Page 6, my lord.
Page
6.
6.
22/5/2026. In compliance of the judgment dated 5/3/25 passed by the Honorable Supreme Court in SLP so and so, S.N. Sarma and others, in contempt petition number so and so, approval of the competent authorities hereby conveyed for extending consequential benefits to Sri S.N. Sarma in place of notional benefits granted earlier.
So where is when it is paid?
Sorry?
When paid?
Lordships, yes, for that purpose, my lord, we have said, my lord, the next document, if your lordship will see, because he was working in Bhutan, so we need his last pay certificate, etc. For that purpose, my lord, we have prayed for 2 months' time so that we can compute it and make the actual disbursement, my lord, to him.
It's the same thing, Milos.
After once, my lord, we have already, my lord, on 18/5, we have sent a letter to Bhutan, my lord. And immediately
Manoj had specifically given 2 weeks direction when my nurse senior had already sought sufficient time. Manoj, what happens is, Manoj, now after issuing this notional reverse to be converted into consequential, now there's a notional benefit that again been granted to me by virtue of this order. They want to sit on computation for a long period of time. Manoj, and page 18 of my reply of the main petition, Manoj, I have given the entire computation. It has not been disputed.
Computation is fine.
Yes, Manoj.
Initially, what they were saying, Mr. Singh,
Please, Manoj.
that compliance notionally.
Please, Manoj.
Then we have interpreted, no, our intention was that we granted the relief as prayed for in the petition. So
Yes.
meaning thereby that would be a all consequential benefits.
Please, Manoj.
So now they have passed the order of grant of the all consequential benefits. What they are contending in this application is
Please, Manoj.
that they have to seek some.
we are not contending, my lord, we are praying, my lords.
They have to seek clarifications. Therefore, for that purpose of clarifications, 2 months time for payment is to be granted.
Yes,
But principally, they have taken a decision to grant all consequential benefits.
that's correct.
So we take this fact on record.
Lord.
We say on or before 2 months, they must pay you.
Lord.
That is all.
That's
very,
all.
Very well, Manoj.
That
Because,
will do.
no, Manoj, because my lords have kind of
We have seen.
observed
You are,
everything.
not, you are not understanding that they were not granting you benefit.
Yes,
That
Manoj,
in
now-
our order, they have granted this benefit.
Yes, Manoj. Now the difficulty now would be, Manoj. Now they.
There you must be happy, sir.
Because I am, Manoj, I'm extremely grateful for the direction Manoj have passed, Manoj. I'm only beseeching Manoj to consider this one small aspect, Manoj. The issue of what is due to me, what is to be paid to me, Manoj, was, and what are my documents available with them has always been available with them since the very beginning. Now,
You are saying quantification issue.
Manoj, the
We
quantification
are
issue.
saying principally let it be, this quantification would come when the amount which is going to be received
Yes.
is less.
Yes, that's
Very,
correct.
Very well, Manoj. It may consider my the competition. They may be, Manoj, while issuing directions.
In furtherance, in pursuance to the order dated 8/5/26. Asking the proceedings of the state. Now, the Government of India, through Ministry of Justice, with the order dated 22/5/26. Granted approval of the competent authority and approval to the competent authority to extend the consequential benefit to Mr. S.N. Sharma.
Oh my God.
In terms of the
69
order dated 5th March 25 and the order dated 8/5/26 in the proceeding. Full stop. The compliance affidavit, a prayer is made for payment as per the sanction dated 22/5/26. 2 months time may be granted. Full stop. In the interest of justice, for compliance of the order dated 22/5/26, 2 months time as prayed is allowed. Full stop. On such payment, while making such payment, the respondent shall clarify the petitioner how and in what manner the fixation has been done.
Okay.
Full stop. In case the petitioner do have any objection thereon, he is at liberty to apprise the government or otherwise by filing a rejoinder for this court that the due compliance has not been made. Full stop. This in the month of August.
My lord, one more indulgence, my lord, that this may be not be treated as a precedent and it may be treated in the peculiar fact of this.
The order.
No, my lords, that may also be mentioned in this order, my lord.
Sanjay, we can't say so. Region, we have passed an order to grant the consequential benefits, and you are asking why a subsequent order we have to dilute our order.
No, no, no,
Sorry,
no.
sir. You can say whatever you want to do.
No, in the peculiar facts of
say
this
so.
case.
Sir,
My lord,
you can't say so.
in this case, your lordship have been pleased to pass the order.
This is our dismay. We are saying clarifying you very frankly, and this is enough to take a cognizance of this against this man. This was not an order of us. We are not speaking doesn't mean that we have not seen.
As your lordship.
Say whatever you want to say.
So, my lord, this is the matter where your lordship directed regularization of 5 workers. Then when your lordship passed that order, you gave us a draft, we looked at the draft, the other side looked at the draft, and by consent, we said there is no minor error. Then after your lordship made the order regularizing 5 workers, review was filed.
Without interim.
Review was filed.
They leave in this matter.
Yes, so it's come
Let
to
it be heard.
it's come to an end virtually, sir, now. Review dismissed.
Lordship,
Now,
may I
after
kindly see
review
there is one-
dismissed, they are trying to take out a clarification application. Review. Therefore, now they must implement, that's all.
Towards the implementation, there is some difficulty. That is why the clarification application has been filed. And
Review
moreover, there is an
dismissed.
IA also has been filed the other
Clarification.
day, but it's 2 days back, an IA has been filed. We would like to file our reply to the IA also.
No, wait now, I don't want to hear your chatter here.
One by one.
1616.
There is the main order.
Yes, Lord.
Yes.
Date.
Now this is an application, miscellaneous application.
25/7.
I'm appearing for the university for the miscellaneous application.
That
3636.
is by the other side, after the review is dismissed,
3566.
application for clarification. After review is dismissed.
You filed the contempt.
I filed a contempt.
What happened?
Your lordship said regularize all 5.
No, that is a main order.
That's the main order.
Main
Yes.
judgment.
The contempt. Now what
Yes.
they are saying? What they want to say?
They wanted to say we are going to file a review, which they subsequently did, which your lordship subsequently dismissed.
Here is that MA. MA number 3566 of 26.
3566 of 2026 minutes.
Not numbered as yet.
3566 of 26.
Can you do clarification after review is dismissed?
Minutes, there are certain points. Minutes. There is the UGC Grants Commission which is staring against us. We have to comply with the UGC Grants Commission's guidelines.
Same grounds taken in review, same
No,
grounds
no.
taken in
No,
review.
no. There are certain other points, valid points to be considered by your lordships. I request.
Mr. Radhakrishnan, and what is this MA?
This MA is for a clarification minutes. And now
Direction. First come to the direction.
the directions minutes. Lordship, may I kindly see on page 23 of the MA, the prior. On page 23 of the MA, the prior. In view of the above said, it is respectfully prayed that this honorable court may be pleased to clarify that the regularization is to be given first to those selected through the recruitment process as per University Act and statute, or to the respondents as number of vacant posts in the cadre of assistant professor is only 205. So the recruitment process have been conducted minutes.
Radhakrishnan, please.
Yes.
Here you are reading this document.
Minutes, page 23 of the MA, miscellaneous application 3566 of 2026.
Read.
I hope your lordships are there. The regularization is to be given first to those selected through the recruitment process as per University Act and statute, or to the respondents as number of vacant posts in the cadre of assistant professor is only 205.
What was the original direction issued by us?
5 workers who work for 12 months.
This is not a way, sir.
Yes, ma'am.
Let us understand the case.
Yes, ma'am.
Let me put it across minutes.
What are the original direction by us?
Original directions minutes lordships will be getting in the on page 82 of this MA. Your lordship's judgment, paragraph 6.
Read.
Paragraph 6.
Yes, sir.
After hearing the Learned Senior Counsel appearing on behalf of both sides, it is seen from the record that out of all the writ petitions filed praying for regularization, 5 teaching fellows, namely so and so, were granted regularization, were not granted regularization is a position. Their case for regularization be considered and appropriate orders as directed be passed within 8 weeks from today. it is made clear that the benefit of regularization shall accrue from the date of the order of the single judge, that is 9/11/2020, though the consequential benefits shall flow notionally. And paragraph 7, so far as the direction for the grant of monthly gross salary of a regular assistant professor to teaching fellows is concerned, with respect to the respondents, other respondents around 50 are there minutes, it will suffice to observe that the said benefit would be applicable in terms of the directions as issued by the learned single judge by the order dated so and so from the said date. Now, my difficulty, minutes, is that
Who are
proper
you?
recruit.
Who are you?
I'm the university minutes, the registrar of the
Were
university.
you heard at
My
that
hum-
time when this order was passed or not?
Regular pardon?
Were you heard at that time when this order was passed?
Yes, yes, I was heard. Minutes, some difficulties
Heard at that time.
arising
Now,
in the
what
implement.
point out? Let us understand your difficulty, please.
My difficulty is minutes this. Your lordships have directed 5 persons to be regularized.
We have not directed. It was a direction issued by the High Court. We have reiterated the same.
Yes, minutes, I bow down. I bow down. I bow down. I bow down.
What remains in this? This MA is not maintainable at all.
My only point, minutes, is that now there is a batch of people who have been selected after the proper recruitment process. Now, whether they should be appointed first or these people should be appointed first, this is number one. And number 2, minutes, is that can we appoint by creating supernumerary posts for these 5 persons with the approval of the syndicate and appoint them? This is all.
Please listen us. Please, who filed the review against this order?
The registrar filed the review. And
That review was rejected.
That was dismissed. And now
review was rejected. What was the prayer made in that review? What was the grounds taken in the review, please? Can you say us?
That is not, I am having not that file with me. But the review minutes is, of course, raising all these points. The review has been filed also. That has been rejected.
In this miscellaneous applications?
Minutes, miscellaneous application minutes. I respectfully submit. Minutes, I respectfully submit that 1/6. Yes, minutes.
Taking all these grounds, you filed the review dismissed.
Yes.
All right. Now you file a miscellaneous application.
Now,
this can be entertained?
Minutes, they have submitted an application for a curative petition also. I am told, I am instructed. That is a position. But the university is confronted with the real situation, minutes, how to implement this judgment. Now, Lordship may kindly, we are safe in your Lordship's hands. I respectfully submit and I humbly submit. Now, our problem is whether we can create supernumerary posts, 5 posts, and accommodate them with the approval of the syndicate. We can immediately do that. We can immediately do that. And moreover, with respect to the other 50 persons, they are not. They are not.
Who are you, madam?
My lord, I filed an intervention application in this matter. The only
We are not. In which case you filed? Business application?
Yes, my lord.
Who are you in that
My
business application?
successfully cleared the assistant professor.
We are not
exam.
concerned of that.
My lord, the implementation.
No, nothing can be done. Who are you? We
My
are
lord-
concerned with our order.
My lord, I'm just seeking
nothing can be done,
clarification
madam.
of this.
Were you a party in the writ petition? This
No.
SLP?
No, my lord.
Who are you? How we can hear you even a second?
My lord, I'm
No, sorry. Okay. The business
have been
application.
filed in the High Court of Madras minutes.
Diary number so and so has been filed. Seeking modification, the order is 25th of July 25, passed in so and so. Full stop. It is not in dispute that seeking review of the said order, the review petition was filed. So number निकाल लेना review petition का, which was dismissed on so and so date. Full stop. Now, on the similar ground, this application seeking modification has been filed. Full stop. In our view, such application is not entertainable. Full stop. And not maintainable in view of the judgment of so and so.
My lord, I may withdraw my IA to pursue my
Accordingly, the application seeking modification is then dismissed.
My lord, I may withdraw my IA so that my liberties are not lost. My lord, I have
The relief granted may be confined to only the respondents' minutes. That may kindly be made clear. Otherwise, minutes. Now, 28 writ petitions have been filed in Madras High Court.
My lords, my IA for intervention that
IA
will
number 7 जिसमें लिख रहा हूँ ऊपर IA number 7 ऊपर लिख देना permitted to withdraw by the council for
142587. And 42587.
Next, come. What about compliance, sir?
Millets, may I submit millets while my lords can consider
You are appearing for
the university in the contempt millets. For me, it's
double
too-
engine.
No millets.
Modification,
No, no.
someone else.
I've come for an olive branch millets. I'm not picking up an issue with them. I'm only submitting what we can do practically, and we will do it. Your lordship's order will implement.
Have you done within 8 weeks or not?
Yes.
Then nothing can.
May I
be done.
just submit one thing?
No,
Millets? May I submit?
sir. You have not complied the order. Finish it.
I only suggest one thing, millets, because on instruction.
Let us understand in this case.
I absolutely agree, millets.
You
Once
take
that is attained finality,
whatever can possibly be done. All right, and now we did it.
millets, we will implement the order. Millets,
When
now,
implemented.
millets, as based on their seniority, I was told that one of them has left the country,
How you
only
had
4 of them remain.
Millets or not, please answer of this.
It's not been. It's not been the case.
And we
I'm
have-
only submitting for my lord's kind consideration.
Who would
We'll
remain
implement
present
that.
in the next
Millets.
state? Please tell us. Either comply or remain present.
We will. Millets. Only thing is that, millets, as and when the vacancy comes by way of superannuation, we are giving them 4 of them. One has left the country, I was told.
We have not said anything for that. We are concerned whatever we have said. You are asking what is it between lips and cups. We
Right,
don't say
right now, Millets, there are no vacancies, I was told. And in the maximum in 4 or 5
We can
months,
create
millets, they
vacancies.
will all be getting the regularization.
Supernumerary
In terms of-
vacancy we can create.
We are not saying anything.
I agree, Millets.
Again,
Millets, the difficulty is this, Millets. Now,
the order dated.
the practical difficulty, Millets. My lords may kindly observe, it may not be treated as a precedent because now more than 100 writ petitions have been pending based on this one, Millets. All of them saying that one who have been recruited.
Sir, you are aware since the order
Millets,
dated-
kindly confine that to the facts of this case, Millets. We'll implement that one.
Not as a precedent.
That liberty may be given, Millets.
has not been complied with. However, the application seeking modification filed by the university has been dismissed today. Therefore, in the interest of justice, today, however, today, wherein we have observed that this review
6 weeks.
has also been dismissed. Full stop. In any case, with reluctance in the interest of justice, we grant 4 weeks time to submit a compliance report.
Millets,
Otherwise,
may finally plead, Millets, 6 weeks. 6 weeks will implement. 6
name of the registrar. Name of the registrar. Otherwise,
Kumaresa.
Dr. Kumaresa.
Doctor so and so, give the name and put,
I'm giving Millets.
would personally remain present on the next date. Date लगा देना, July.
Millets, may I pray, Millets? May I pray?
And
Millets, only one
Millets,
indulgence, Millets.
may I make one submission, Millets?
Kumar's son,
Yes, Millets, Kumaresa.
University Chennai.
Yeah.
Personally remain
Millets.
Millets, with your lordship's
But small
kindly,
indulgence,
I
Millets.
may be allowed to make one submission.
Only
Millets.
thing
One
is that,
submission.
Millets, let it not be a precedent where, because all those applications can be fought on their own merits, Millets.
Millets,
That
may I-
indulgence, we are
Millets,
implementing this, Millets.
And so
Millets,
what they've
I
done
may
is
be allowed to make one submission, Millets. We
all
may be
5
allow-
have
we
been
may be
kept
allowed
without
to-
salary.
Millets, we may be
Since your
allowed.
lordship's order, all 5 are without
Millets, my
salary.
instruction is one has left the country. I don't know whether he has come
We
back.
are seeing Mr. Gonzalez, what we are doing. Let
You're
them
try-
do something.
You're
Let
trying,
them
I
do
appreciate, Lord.
something.
Millet.
Let them do something.
Could my lords accommodate us, Millets?
6 weeks.
We'll fight the rest of the cases on their own merits,
We
Millets.
have 6 weeks, only thing.
6 weeks.
We have said 6 weeks, sir.
I'm grateful, Millets. Let it not be a
Grateful.
let it
Otherwise
not be a
ungrateful.
precedent, Millets. As far as the cases are concerned,
Otherwise ungrateful.
I'm always grateful, Millets. This indulgence is more than enough what we could expect, Millets. The only issue is that, Millets, now university has been inundated with writ petitions. Let them be considered, Millets, on their own merits.
If they will not comply, let it be closed like this.
Now,
He will close otherwise.
now all these people who have been given this contractual basis backdoor, they get the right royal march, Millets.
Not that much
So that
case,
we
sir.
could fight
This
them.
Case enough. I have heard it
Only
through
because
length.
the
We have
cases
seen
that
the
have-
order, it was a detailed order passed by the High Court.
I do appreciate. The
I have
cases,
seen at that time examined this order passed.
the cases
aware of
pending before the Madras High Court, Millets, all that indulgence.
Sir, we are aware, Mr. Ramaji.
So be it. Great.
This is another way. In fact, we have not dismissed with cost. It is enough. Otherwise, we would have dismissed it with cost of rupees not less than 5 lakhs.
Very true, my lords, very true. We are
In the
grateful.
manner, review all grounds taken. Now modification, you are taking all grounds. And now you are asking, we will
That
not do it.
university millets constrained with funds, and
Very
UGC will not grant us the funds because of their own constraints. So be it. Great.
Thank you very much.
Minute, please, Manoj. I beg to appear for the petitioners.
Yes.
By the last order, Manoj, your lordships had directed the contemnors to be present here.
Yes.
After your lordship's order, while dismissing the SLP, was to file an undertaking and pay all arrears and then vacate also, Manoj.
Yes.
Very cleverly, Manoj, they go and file an affidavit of undertaking before the High Court, saying that according to them, there is some amount that I have to pay to them, which has been already found to be fraudulent, and the anticipatory bail rejected. They are projecting some agreement which has been rejected by the trial court also and the High Court also. Your lordships have already dismissed that SLP, my lord, and allowed him to, asked him to vacate, pay the arrears, my lord, which is now amounting to 9 crore. Please come to page 12, my lord. Very blatantly, they have not paid this arrears. Now they have vacated, but then they are not willing to abide by your lordship's order, my lord. Look at the conduct. Earlier round also on bail also got
First date.
Sorry, my lord. Issued notice and asked them to be present here today, my lord. Your lordships had issued notice
Yes.
and asked them to be present here, my lord.
Yes.
I think he's here.
What was the direction, madam? Please.
27th April is the order. my lord.
That direction.
Yes. The alleged contemnors are required to remain physically present before the court.
No. Mean order. Mean order.
Yes, page 21. No?
Yes.
Sorry, 20, it starts. It will be second para.
Vacate the suit premise up to so and so.
In fact, the
Subject to
grant
payment of arrears of rent
within 1 month and regular rent on month-to-month basis. It is directed that the
What is the
petition.
undertaking filed by them?
Yes, he files an undertaking like this.
Please show us undertaking.
40.
Yes, sir.
That's this affidavit is filed in compliance. The lordships had directed them to file it in the High Court. So therefore, we were directed to file an affidavit to vacate the premises, and we shall do so and so and so. I humbly submit that regarding payment of arrears of rent, I humbly submit there are no arrears of rent according to me. And the decree holder is already having my 6 crores, and for payment of rental arrears, a suit of 2020, which is for the old arrears, is already pending adjudication before the additional city civil court, which was up to 2020, that suit for 17 lakhs. Now, my lord, he has not paid thereafter also, and your lordship said pay all of them. After availing this, he is now saying.
Decree.
Yes.
Come to the decree. Let
Yes.
us see if he has not complied with, he has to face the consequence.
Yes,
Please tell us what is the decree part.
Yes. Parent order. EP.
What is the decree part?
Yes, no. Your lordship will find that in the main SLP. That will be.
Yes.
That will be in the main SLP, no?
Where is the decree part?
Yes, I'll just read. That will be in the main SLP, my lord, which may not be before the lordships. Yes, 24.
Page number 34, my lord.
The point is, to avail the benefit from this honorable court, he had given the undertaking. To avoid the order of eviction, he has to given
Let's understand.
Yes.
Where is that the decree? What was the decree of arrears?
Yes.
You have to understand that part.
65 in the petition, which is the page number 49. Yeah?
Page 49, contempt petition.
Page 49 of
The contempt, that's a fair rent order, no?
May say so.
what chance will come? We will wait.
This will be,
Chance will come, we will wait.
yes. This is a section 4 order. Lord. This is asking about eviction decree, which is in the main matter. Okay? Yeah.
What is that?
Yeah, this will be in the main paper. This one. Page number 37.
65.
37. 37 of the contempt petition.
37.
37 is the EP order. The EP. It's asking about the main order. That is the decree. This is EP. No, main EP, main RCUP order. This is the one, 65 to 82. Page number 81 of the main SLP minutes. That starts from 65.
Yes, 81.
Yes. Directed to vacate and deliver vacant possession within 2 months from that day. That is in 24 April. No, be here. I don't need your instructions. We know that it's not here.
What was the agreement? In
Yes.
terms of the agreement, what was the rent?
Lord, the rent was 1,98,000 initially.
Where is it from? Where we can get it?
Admitted rent, yes. Ma'am. This was a, thereafter, my lord, your lordship will find the fair rent order in which it is mentioned, my lord, which is the fair rent order, which is on record
Where is that?
in the contempt petition, 49, where they fix it, my lord.
Where is that 49?
Yes, of the contempt application. Fair rent is page 62, your lordship will find it 9,84,827 at 62 of the contempt petition.
Yes.
Lordship's got it, my lord?
This
9,824,827. Which
This would be from which date?
26/4/2018. In that para itself, it is there. There is no appeal against this. This has attained finality.
Yes.
So therefore, my lord, from that time also, he has not paid anything. It is at page 12. I put the calculation of the contempt application. I have given a calculation.
Page 12.
Page 12, my lord.
Okay.
We have given it, my lord. We have given credit.
9 days.
Yes.
For 9 days, 84,000.
92 months. 92 months, 9 crore 6 lakhs.
Till December, 9 crore 6 lakhs.
Yes.
Then
Security deposit with me 9 lakhs. Then I have reduced that. Outstanding arrears is now 9 crore 8 lakhs 4,084 rupees is to be paid to me.
yes, sir. That is all.
Yes, bro.
Yes, please.
हिंदी में बात कर सकते हैं, हिंदी में बात कर सकते हैं, इंग्लिश में?
हिंदी में बोलिए, हिंदी में बताइए।
मतलब मैंने एक SLP फाइल किया था, मतलब SLP फाइल किया था। SLP वाज अगेंस्ट मिलॉर्ड वो हाईकोर्ट का ऑर्डर जहाँ पे खाली करने को बोला था मिलॉर्ड, वो जो प्रेयर ऑफ मनी उसमें नहीं था मिलॉर्डशिप, उसमें सिर्फ खाली करने का ही प्रेयर था। 21(2)A में उन्होंने फाइल किया था मिलॉर्डशिप। वो ट्रायल कोर्ट में डिसमिस हो गया मेरा, उनका अलग हो गया, मेरा काउंटर डिसमिस हो गया था। वो डिसमिस होने उन्होंने एक सूट फाइल किया था मिलॉर्ड, जहाँ पे उन्होंने 70 लाख रुपए रेंटल एरियर्स बैलेंस है करके बोल के सूट फाइल किया। सूट पेंडिंग है, वो मैं सूट में कंटेस्ट कर रहा हूँ मिलॉर्डशिप। लास्ट 4 हियरिंग से उन्होंने कोई भी आया नहीं मिलॉर्डशिप उस सूट में, वो सूट में मिलॉर्ड। दैट इज पेंडिंग बिफोर 17th एडिशनल सिटीजन कोर्ट मद्रास।
ये जो अंडरटेकिंग था या जो ऑर्डर था, इसमें कोई सूट के बारे में था क्या?
नहीं था मिलॉर्डशिप। मैंने मेरे एडवोकेट
सूट का यहाँ बहाना
मिलॉर्डशिप,
ले सकते हैं।
मैंने मेरे एडवोकेट को बोला मिलॉर्ड ने सूट बोलो, वो बोले सूट सुन ही नहीं रहा है, क्या करूं, रिव्यू फाइल करो। मैं एक सेकंड मिलॉर्डशिप, एक सेकंड मिलॉर्ड, मैं कुछ बोल सकता हूँ?
ये बताइए ना, आपको सुन ही रहे हैं, पूरा सुन के ही करेंगे, आप चिंता मत करिए।
फिर उन्होंने कहा, मैंने बोला मिलॉर्ड वो सूट का तो आउटर में कुछ आया नहीं है, सूट का बोलिए, सूट पेंडिंग है, सूट हम चला रहे हैं, उसमें अगर मेरे फेवर में आते तो उनसे मुझे 6 करोड़ आना है। तो उन्होंने बोला उसे तुम सूट में देख लो, क्योंकि अमाउंट कुछ डिटरमिन नहीं हुआ है, सिर्फ खाली करना, तुम जितना जल्दी हो सके खाली कर दो। मैंने खाली करके चाबी भी मैंने कोर्ट में हैंड ओवर कर दिया मिलॉर्ड, और मैंने दूसरे घर भी शिफ्ट हो गया। अभी वो जो बोल रहे 9 करोड़ का अरियर है बोल रहे हैं मिलॉर्ड, दैट इज फ्रॉम अ फेयर एंड पिटिशन वेयरइन एन एक्स पार्टी ऑर्डर वाज पास। मैंने पिटिशन भी फाइल किया, वो 6/2 को लिया टू रिकॉल द ऑर्डर, 6/2 को कोर्ट में लिया है मिलॉर्डशिप, उसमें नीचे स्मॉल केसेस कोर्ट में।
कब चैलेंज किया वो?
चैलेंज नहीं, क्योंकि एक्सपर्टी ऑर्डर करके पिटिशन फाइल किया है 6/2 में, वो अभी लिया नहीं मिलॉर्डशिप उसने, मेरा काउंसिल फाइल किया है।
जमा कर दीजिए, तो पैसा जमा कर दीजिए।
मगर उतना पैसा है नहीं मेरा पास।
नहीं है आपके पास तो आप भेज जाइए, दोनों में से एक काम करना।
मगर एक लॉर्डशिप, उनका लॉर्डशिप का ऑर्डर पास कीजिए। लॉर्डशिप काइंडली सी द ऑर्डर फॉर अ मोमेंट। इसमें लिखा हुआ है नो थर्ड पार्टी राइट्स शैल बी अंडरटेकन।
इससे ऊपर पढ़िए जरा।
नहीं मैंने देखा है मैंने
इससे ऊपर
मैंने
पढ़िए
मैंने
ऊपर।
मैंने वही टाइम मैंने
पेज नंबर 21 पर
हाँ
पढ़िए
हाँ मैंने
पेमेंट
हाँ यस
एरियर्स ऑफ रेंट।
यस मिलोड
तो जिस वेकेशन वाज फूड प्रॉपर्टी अप टू इतने इतने सब्जेक्ट टू पेमेंट।
यस मिलोड
सब्जेक्ट टू पेमेंट का मतलब समझते हैं ना?
हाँ मैंने
तो केवल खाली कर देना पर्याप्त नहीं था, साथ में आपको एरियस का भी पेमेंट करना था। और एरियस ऑफ पेमेंट के नाम पर आज की तारीख में स्टैंडर्ड रेंट डिटर्मिनेशन का ऑर्डर है ना आपके अगेंस्ट?
हाँ मैंने
यदि वो ऑर्डर है आपके अगेंस्ट तो हमको वो मानना पड़ेगा कि स्टैंडर्ड रेंट ये है और उतना पे करेंगे।
मगर उस
अगर आपको लगता है कि ये भाई ये नहीं, इनको अभी नहीं देना, वो आपका केस पेंडिंग है, तो आप डिपॉजिट तो कर दीजिए।
नहीं, उन्होंने
फिर देखेंगे उसको।
उन्होंने एक बात बोलना मैंने उन्होंने रिकवरी मगर प्रेयर बस सिर्फ खाली करने के हाईकोर्ट में था मैंने खाली कर दिया आज मेरा पैसा।
आपने ये ऑर्डर देखा हमारा या नहीं देखा?
हाँ देखा मैंने
पढ़ रहे हैं आपसे आपके
नहीं
सामने।
मैंने समझ गया मैं
कितने
पढ़
पढ़े लिखे हैं आप?
मैं बीसीए मैंने
अगर आप
डिसकंटिन्यूड
किया तो इतनी अंग्रेजी तो आप समझते हैं?
नहीं
बोल नहीं सकते लेकिन समझते तो
नहीं
होंगे।
बोल सकता हूँ मैं बोल भी सकता हूँ
बोल भी सकता हूँ तो आपने हिंदी में बोला इसलिए हम हिंदी में बोल रहे हैं आपको। ठीक है, तो ये है सब्जेक्ट टू पेमेंट ऑफ एरियस ऑफ रेंट विद इन 1 मंथ। तो 1 मंथ में आपने नहीं किया
मैंने
एंड रेगुलर रेंट इन 1 मंथ ऑन मंथ टू मंथ बेसिस, ये भी आपने नहीं किया। अब इसके कारण आप कुछ भी बता सकते हैं, लेकिन आपको तो ये अंडरटेकिंग देना थी, लेकिन आपने ये नहीं दी। इसका मतलब ये है कि हमारे आदेश का पालन आपने जिस तरह से करना चाहिए था वो नहीं किया और उसी की वजह से आप यहाँ आज खड़े हुए हैं। तो अब हमको क्या करना चाहिए? या तो हम ये कहें कि आपने आदेश का पालन नहीं किया, आप जेल जाइए, एक बात, या हम ये कहें कि भाई आप उसको करना चाहते हैं तो हम आपको समय दें, 2 बात। कौन सी बात पसंद करोगे आप? आपको दोनों में से कौन सी बात पसंद है ये बता दो। या आपको कहिए भाई आपको कोई वकील दिलाना है, हम आपको वकील दिला देते हैं, हम आपको वकील भी दिला देते हैं, यहाँ से वकील भी आपकी तरफ कोई, हम सरकारी वकील यहाँ से कोई वकील अपॉइंट कर देते हैं। आप बताएं क्या चाहते हो?
सूट में उन्होंने 70 लाख क्लेम किया मैं उसमें डिपॉजिट कर दूं
नहीं वो नहीं कर सकते ना,
सूट पेंडिंग है मैलॉर्ड
वो बात नहीं कर सकते। आपको हमने बता दिया, आप नहीं समझ पाओ तो हम इसके लिए कोई रास्ता नहीं हमारे पास।
फेयर इन में मैंने एक्सपर्टी ऑर्डर करके मैंने पिटीशन फाइल किया है मैंने रिकॉल दी ऑर्डर अगर वो ऑर्डर रिकॉल हो जाता है तो फिर अपना केस चलेगा मैंने वापस वो।
अच्छा आप ये कहना चाहते हैं कि वो हो जाता है तब देखेंगे?
नहीं वो
आपका जो ऑर्डर है उसको रहने दीजिए।
नहीं मतलब मैं वैसे
फेयर रेंट के ऑर्डर को लाएंगे?
नहीं मैंने नीचे आपने लिखा है कि
कहना चाहते हैं
नहीं मैं वो नहीं बोल रहा हूँ मैंने
तो फिर क्या बोल रहे हैं आप? बताएं आप वैसा बताएं, वैसा लिखेंगे हम, क्योंकि हम ये लिखेंगे ऑर्डर में तो वही बात लिखना पड़ेगी ना हमको।
ये लाइन
कुछ और कहना है आपको आदेश लिखने से पहले?
मैं
तो आप क्या चाहते हैं?
एक एडवोकेट टेक्निक का परमिशन दीजिए मैंने
मैडम
Yes.
can you assist in this to him?
She has assisted me in this matter. She's my office colleague.
Sorry.
I'm sorry.
You assisted to this?
For this case, she
No,
was.
no, I am asking her.
Sorry.
I am asking. I am giving
I'm
senior.
sorry. I thought she was saying I have assisted, so I thought she was the.
No, I am giving a senior advocate.
Yes, yes.
To him. What
Yes,
more
yes,
I can do?
Lordship may see the order while dismissing the SLP.
Some AOR also. You give it some AOR.
That is
name.
Yes.
Yes. Yes, in person. Petitioner appear in person. Oh, respondent contemner appear in person. In the course of this case, we deem it appropriate to appoint learned senior counsel so and so to as Amicus to assist on his behalf, along with AOR का नाम लिख देना।
गगनबोध
No, it's not his name, sir. AOR का नाम लिखना। पूजाधर। Full stop. We may file counter affidavit within 2 weeks. Full stop. to some, or to, you may comply the order or to submit a counter affidavit before this condition.
Just one prayer. There are 3 respondents, all are served, all were parties, they are all brother and sisters, my lord, brothers and sisters. They did not appear today. Lordship may just note that service is complete on them, the order.
My lord, second Sandeep Botra, उसकी
Your good name, sir?
गगन बोत्रा my lord.
Gagan Bothra is present. What about 2 and 3?
My lord, संदीप बोत्रा उसकी अभी शादी हुई my lord, honeymoon गया हम.
Whatever it is, sir. We are
10
not
दिन
interested in
10
that.
दिन ही हुई में शादी हो गया.
We have asked them to remain present. They are not present.
My sister is appearing online my lord, TV में, unmarried my lord.
Who is appearing?
TV में है my lord.
Who?
मेरी बहन three करिश्मा बोत्रा.
करिश्मा कनेक्ट करिए, उन दोनों के बिहाफ में इनको काउंसिल दे दीजिए. Why is not present too? Have you filed any application for exemption of appearance?
नहीं.
We have asked the contaminants to remain present before the court. We have not asked the virtually.
आज फाइल कर देते हैं.
Okay. Contaminant number 1 is present in the court. Karishma.
No, I'm Gagan Botra.
We are aware, sir. Please wait, sir.
Sorry.
We are getting connect this. Karishma, you are saying she is on virtually present. Hey, Karishma? Not connected, Karishma.
मैं तो रहूँ. मैं बाहर से बोला था कि आएगा लिंक बोला ऑन करेंगे आप आ जाना करके. क्या मैं बोलूँ मिनट फोन में.
Sir, I'm actually connected. Sir, I'm M. Karishma Botra here. I'm not able to view the video, but I can hear you and I hope you can hear me too.
This is not enough, madam.
Sir, my video is not being visible. It says court number 3 has currently stopped your video. I don't know what is the issue.
Open it.
So I'm trying, sir.
We have opened, madam. You unmute and mute.
Sir, I'm unmute actually now, but video नहीं आ रहा है, पता नहीं क्यों. It only shows a stop video.
She will have to click that.
Otherwise, also we have directed for remain present, not virtually.
Sir, actually, I don't know anything about this case. My brother just asked me to appear. Earlier, I was under the care of my father and brother.
Contempt, otherwise you will face the consequence also.
And sir, I actually have nothing to do with this. I was only under the care of my father and brother earlier. And now I'm under the care of my brothers. I don't know what exactly is the case is about.
The order, otherwise you and your brother and everybody would be in trouble. Because the case of non-compliance, it is not a simple case. It's a personal responsibility.
I don't even know what exactly is this case about. We were just asked to.
Requesting you, we are granting you some time, you know, and do the needful. Understand? We are not condemning unheard. We are giving you an opportunity once. Fine?
Sir,
Virtually.
Sir, can I just speak something, sir? 2 minutes.
Not working. Full stop. But his brother who is present in the court, Gagan present in the court, said he is my sister. Full stop. Number 2 is not present. It is informed that he has recently been married. However, recently been married. Recently been married. So not. Full stop. Let him remain present on the next week. Full stop. Considering the facts and circumstances of the case, we requested the senior counsel to answer. बाकी पर वही उनका वो लिख देना for the Jamaica's special sport. The 11 counter affidavit be filed, Baki 4 weeks. File a counter affidavit, then asking with him, and then we look into.
Yes, ma'am.
You have a connect
yes.
with ma'am.
Very well.
Okay, fine.
Does that, my lord, one aside is that they are all money lenders remaining absent in all criminal cases. Orders have been issued for their arrest. They went to jail, came out.
Your argument reserved.
Yes, yes.
Keep
I
your
just said
argument
they are
reserved.
very cleverly acted innocent today. Very well.
Let them appear, let us see.
Yes, yes.
Let them file counter, let us see.
At least 150 cases are
We'll
there.
see. You can file a detail also.
Yes.
2 weeks for rejoinder.
Very good.
Exam.
Milord, 150 cases.
We are not saying, sir, please don't contest. You are a contemner at present. You have not complied the order of this court. You have to understand this part. We are giving you an advocate also prior to passing any order against you. You have a contact and do needful, please. 58.
With my lord's permission. This is the matter where my lords had permitted us to issue dasti as well. In terms of the facts, it could be referred for mediation.
Nobody is appearing for the
No,
other side.
Miss.
I'm here.
Uh-huh.
Lord,
Okay, fine.
yeah.
Yes, please.
So, my lord, this was the matter where my lords, we had felt, indicated that they should go for mediation because both the parties are US citizens with both the children who are in US are born and brought up in US and they're litigating in Goa. Matrimonial disputes are going on, various litigations. So what had fallen for my lords was that this is a matter which could be referred for mediation, and that's why my lords had issued notice for preponed the date for.
Refer for the mediation.
My lord, may I just give two aspects? One, they've wrongly mentioned for relocation when they've done a mentioning for former. There is this
Wrongly mentioned.
that it was with regard to relocation. It is a case of confidentiality where the court has passed in camera proceedings. That's the only aspect where they had in fact conceded before the High Court two concurrent findings. So firstly, a wrong mentioning done by for your lordship. I'm seeing from the mentioning performer. So there is a huge overreach. And this petition's not concerned about relocation. If your lordship sees para 5 of the impugned order, they have consented there. Two concurrent findings, but they consented. They said, let the order only extend to the children. After that, she's committed contempt. She has relied on that same order, filed contempt, which was dismissed, and notice in my contempt.
You file counter affidavit, then we'll look into it.
Is that fair?
You file counter, then we'll look into it.
Do they, if they want, they do not want for mediation?
Not interested in mediation?
My lord, let me explain one other fact.
Please, you are not interested.
Justice, can I take?
Two aspects, madam.
My lord,
You interested?
on mediation, I just want to address. Justice Joseph had been appointed ad hoc by consent of parties.
No, my lord.
He'd agreed to go to Goa on 8th of March. And before that, on 5th March, they cancelled the mediation, leaving him high and dry.
My lord, that's not.
And we are happy to go back to Justice Joseph.
No. We want to.
Because he had mediated one hearing on one date.
Counter affidavit, we file mediation.
My lord, the mediation center, because the lady has no money. If they want, we can go to mediation center in Supreme Court. Supreme Court Mediation Center.
Let
My-
it come.
My lord,
Counter be come.
they don't want, I'm not fine, deeply obliged.
Counter affidavit.
Laws in 59, I'm seeking some time to file my wakalat. I'm for the state.
Well,
laws.
this is an order which is wholly without jurisdiction with respect. But in the section 37 of the Arbitration Act has a limited appeal on only, it says
You
appeal.
want to file a counter and
But no, on the face of it, if there's just no jurisdiction,
Laws, let me
it's
file
really
my wakalat.
something. How can the High Court exercise a
Singh sahab,
jurisdiction
please.
in 37?
Counter affidavit, wakalatnama and counter affidavit within 4 weeks. Please tear up.
Very good.
Item 60.
No, just one thing. It just may be clarified that there's no stay, because the division bench is hearing our appeal.
Singh sahab, where is the need when we have not passed any order of stay?
Laws, now there's an other.
Where is the need to say so? There is no stay.
My lord, because the division bench is hearing, it shouldn't.
You can say something, we
My
can
lord.
say so.
Very well.
Yes, sir.
My Lords has heard this matter in great detail, all the parties.
No.
We had taken instructions, my lords. They had given us a list of 58 people.
Huh?
They had given us a total list of 58 people. Out of them, 54, their marks are below the cutoff. So there's no question
No,
of.
that's not correct.
Let me hear it.
That's not correct. My Lords, this is completely incorrect. Nothing has been filed. My Lords,
Four have been appointed.
My Lords, if they could be told that should my marks be above the cutoff.
On instruction, they are not ready to appoint.
Yes,
We have
my lord.
passed the order. So now what we can do, we'll hear and merit on, decide, let it go before appropriate time.
My Lords, since my Lords have invested so much time and effort already.
We can do, sir. Today,
My Lords, just a very small request.
Those are my factual instructions.
I'll submit. Only two.
Yes.
Cannot be denied is the fact that preference for me was to be given to us as per the notification of 2015.
You have the note ready?
So they did not. In the compliance affidavit, it clearly states that the preference was to be given to the high, more meritorious. That they don't comply. They give it against below the minimum qualifications to people who are class 10, A pass. It's very important. There were 4 Millot district primary councils. In 3 Millot, we are giving by consent. Now, before this court, when there are vacancies of about 800 people, they say that you are not qualified. Just see the fallacy in the argument.
we are not, we can't.
Correct,
say,
but
we
just
will
look at
see here
what
on.
the state is doing.
Sir, how we can understand this argument on merits, we can understand, we can press aside. But today on merit, we are not here.
My Lords,
The instructions, they are not understand, let it be heard on merit.
My Lords, may I propose a middle ground? My Lords, may I propose a middle ground? Mr. Ahmadi has very fairly said that what had fallen from my Lords in terms of the qualifications, they are then admitting. So if my Lords may place on record, and I have a very short note just to summarize where we are today.
We summarize not necessary. I have heard the argument in this case
Yes.
now 2 days.
Exactly.
So need not do any summary for us.
So if it may be recorded that the NCTE qualifications, what the state is saying.
It is not like that. On that day, we are going to allow that petition. It is not like that, sir.
I'm grateful, my
We are
lord.
going to allow this.
I'm grateful, my lord.
We are not saying of anything because of today we don't have a time to say of anything. Let it go.
No, my lords have recorded that all parties were heard. All parties were.
We are not saying of anything, sir, not affecting to anyone.
But
Go
my
ahead.
lords, just what Mr. Ahmadi was very fairly saying. He was saying that, look, on the facts, we may not be within.
State submits that
Oh, my lords, in the vacation, perhaps.
No, not in the vacation, please.
just before this court.
My lords, in the vacation, will my
No,
lords
no,
be
no.
sitting?
Yeah. By this court. Full stop. However, the case is required to be heard on its own merit. Full stop. Please stop.
Yeah.
लगा दो.
Now, we did retain
The case-
Please, Your Worships.
Fair enough, my lords.
Item 50. Let's carry it around.
हेलो
जी बताइए.
जी सर आवाज आ रही है सर अभी
हाँ आ रही है हमारे पास. क्या नाम है आपका?
उर्मिला बाई.
हाँ. पहले आपने इनकी ये सत्येंद्र ने जमानत के लिए आवेदन लगाया था तब आपने इसको अनापत्ति की थी.
जी.
अभी इन्होंने पूरा केस खत्म करने के लिए केस लगाया हुआ है. आपको क्या कहना है इस बारे में? क्या इनका केस क्रिमिनल केस इनके अगेंस्ट जो है जिसमें आपने इनको जमानत दिलाई वो केस खत्म कर दिया जाए? एफआईआर खत्म कर दी जाए? वो
खत्म कर दीजिए सर.
आप चाहते हैं कि एफआईआर क्वैश हो जाए उसके अगेंस्ट?
जी सर.
My formal objection obviously is there, but otherwise I leave it to Manoj.
I think that his statement must be recorded here in the court. She is required and her statement must be recorded for that purpose. Only if we say something on the next day, suppose he retract from it, it would be a, just we don't want to.
JMFC is there.
आप उनको दीजिए बगल में जो आपके साथ बैठे हुए हैं उनको दीजिए.
There's a lady judge in the.
हेलो
यहाँ पर जज है कोई?
जी सर.
उनको दीजिए.
सर अभी लंच टाइम है तो अभी मैम लंच पे गई है.
जब उनको मालूम था ये केस चलने वाला है तो जज साहब क्यों लंच पे चले गए? लंच का टाइम 1:30 से 2:30 होता है. 2:25 हो रहे हैं.
जी सर 2 से
क्या टाइम है लंच का आपके यहाँ?
सर 2 से है सर 2 से 2:30.
बुलाइए उनको.
जी सर.
कौन सा है?
Baghicha district Jashpur.
बगीचा जिला
Jashpur.
Court would be of this.
Well, it's Balrampur.
Balrampur.
It's a separate district, so the alleged offence took place in Balrampur, but the prosecutrix is resident of Jashpur.
But she has to go to record the statement before the same sessions court where this trial is pending. Or otherwise, because it's SC/ST, so this cannot be recorded by anyone and we cannot take on record. Otherwise, this will be another technical flaw.
Yes, Manoj. Well, we'll fix it on tomorrow, day after. It's not very far from there.
How far it is Balrampur and this?
About 1.5 hours, so about 50 odd kilometers from there.
Can you find out which is the trial is pending or no, what is the stage? Which is pending in the cognizance stage?
Yes, my lords.
Can you find out?
Yes, I'll just point out, my lords.
Lordship, charges have to be framed. Charges have not been
Not
framed.
been framed.
Well, only charge sheet has been filed, my lords.
Filed.
Charge sheet has been filed, but
Which court?
Balrampur, special court, Balrampur, my lords.
POXO court.
POXO, the special court.
Just Balrampur. Ramanujganj. Page 52.
Well, it's the Special Judge POXO Act, Balrampur. Ramanujganj, Balrampur, my lords. That's
This is of the same place. Ramanujanganj would be some another.
Well, it's actually after redrawing of the districts, they've not they've taken both the names. So it's basically merger of two smaller units, two tehsils, and they've made a carved out a district out of it. So Ramanujganj, Balrampur is one district.
Copy to Balrampur, the district is to be victim appeared. Full stop. Appeared in states that she wished that the FIR as registered must be questioned against FIR number so and so. FIR number
135/2025.
135/2025.
Please.
Registered by police station
Balrampur.
Balrampur ought to be questioned against the petitioner. Full stop. Earlier also, when the petitioner came for anticipatory bail, she appeared before the court. However, on her concession, the bail, anticipatory bail was granted on 22/4/2026 in the special leave to appeal criminal number 2121 of 26. Full stop. Today, when she appeared, today on her saying that it may be questioned, he thought it appropriate that her statement ought to be recorded in this regard in the competent court, and it may be transmitted to us. Full stop. The supporting staff of the विधिक सहायता केंद्र बागीचा जिला जशपुर is present. आप उनको दीजिए मैडम को, उनको दीजिए मैडम को. क्या नाम है मैडम आपका?
सर अंकिता यदू सर, नमस्कार सर.
जब मैडम आपको मालूम था ये केस टेकअप हो रहा है सुप्रीम कोर्ट में, तो आप क्यों चले गए?
सर मैं एक्सट्रीमली सॉरी बट इन्फॉर्मेशन नहीं थी सर कि मुझे प्रेजेंट होना है करके.
आपके सामने केस है, चल रहा है सुप्रीम कोर्ट में, यदि आपकी जरूरत पड़ेगी तो आपको इन्फॉर्मेशन देना पड़ेगी. फिर हम आपकी चीफ जस्टिस के यहाँ लिखते हैं अभी आपकी इन्फॉर्मेशन के लिए.
नो सर, एक्सट्रीमली सॉरी सर.
क्या लिखा है? What we dictated? Was present. However, we called the secretary of the Jalsa since her statement is required, since the statement of the victim is required to be recorded by the concerned competent sessions court. Therefore, the communication be given by her in this regard. We also thought it appropriate that a copy of this order be sent to the Registrar General of the High Court as well as the District Judge Balrampur in Ramanujganj, as well as and also to the Special Judge Poxo Court to record her statement tomorrow and be sent to the registry of this court for further orders. Case will listed day after tomorrow. ये copy अभी निकाल के देना order. This copy to me. And madam, communicate to the district judge as well as Ramanujganj Poxo Court. Her statement be recorded. We are sending a copy by the email to everyone. Have you understand, madam?
Yes sir.
Please.
Much of.
Grateful.